Welcome to the first hearing of the Committee's inquiry into the Residential Tenancies Amendment, Protection of Personal Information Bill 2025. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Emma Hurst and I am Chair of the Committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome, and thank you for making the time to give evidence today. Could I ask you to please state your name and position title and swear either an oath or an affirmation?
Certainly. My name is Troy Wilkie. I am the Senior Government Relations Manager at RSPCA NSW. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Would you like to start with a short opening statement?
I would, thank you. To be more effective if we're all here, but perhaps those online can also participate with a virtual hand or something, but hands up who here has or has had a pet. And keep your hand up if you loved that pet. That's unanimous. Fantastic. Reflecting on that same pet that you love, how would it feel to surrender it to a pound despite not wanting to? People who rent are forced to surrender their pets against their will every day. Of all the animals surrendered to RSPCA NSW, around 20% are surrendered solely because they cannot secure rental accommodation with that pet. 50% are due to cost of living pressures, with rental costs a major component. Some may say these families are surrendering their pets and they're irresponsible. I say their situation is a natural and foreseeable consequence of a system that demands they make a 15 to 20 year commitment to an animal while they're only given a 1 or 2 year commitment to stay in their current home. We know people with pets live longer and have fewer health problems, and that renters want pets but can't have them. 70% of all NSW homes have a pet. 30% of rented homes have a pet. This shows the huge impact renting has on pet ownership. These impacts are multiplied for our community's most vulnerable. We help more than 100 families each year through our domestic violence community program. We don't advertise that program, it would never meet demand. There have been clients in this program who were first brought to our attention because we got an animal cruelty complaint about a woman sleeping in her car with her kids and pets. Now, rather than prosecute them under animal cruelty laws, we look after their pet while they get back on their feet to be reunited later on. Recent surveys have shown that around 50% of victim survivors delay leaving domestic violence situations because they're worried about the safety of their pets. Given that we don't advertise this program and it only helps those in very desperate situations, imagine how many women are living in an abusive relationship today because they can't find accommodation that allows their pet to come with them. How many heartbroken families are surrendering their pet today, or this week, or this month, in a desperate attempt to jettison rental application baggage and secure a home? We are grateful for the bipartisan reforms to date that have improved the Residential Tenancies Act. I hope we can make further improvements that will also improve the health and well-being of our communities by making rental accommodation more pet-friendly. In our submission, RSPCA NSW set out simple, practical solutions to improve the implementation of the reforms contemplated, and I look forward to discussing those with you today.
Thank you. I might start with a few questions myself. I just want to ask you just broadly, how difficult is it to rehome a cat or a dog in New South Wales right now, especially with very little notice?
It's very difficult. We've got all of our pounds and rehoming organisations, including RSPCA and NSW, are constantly at capacity. Our foster care networks are at capacity, and that is because we are having longer length of stays that have increased, particularly I'd say in the last few years since COVID. We did have a rise in the number of people having a pet, and then with that larger number of pets in the community, there have been and very significant cost of living pressures, including rental pressures. A lot of people who have needed to try and surrender that pet, and that has caused a really big issue right across the entire network. So length of stays are much higher right now than they have been historically, even pre-COVID in normal times.
Thank you. Under the government's bill, you'll be allowed to keep an animal at a rental property for a very short period of time while you're put in an application to keep that animal. However, if that animal is actually refused, the renter has to immediately remove the animal or they'll be in breach of the lease. How practical is that, given what you've just said?
I don't think it's very practical at all. And I just think it's one of those things that hasn't been contemplated and the bill is currently silent on, that needs to get clarified in the bill to make sure it's implemented correctly. So there's a couple of things that you raised that we've touched on in our submission. The first being that they've got 7 days to apply. Now, moving is not fun. Having 7 days to apply for the pet after having moved in, I don't think is quite enough time. I think 14 days would be more appropriate, and we've put that in our submission. The next part, there's sort of two pathways. Either they apply and it's a yes, which is then a straightforward, no problem scenario, or they apply and it's a no, and that can then lead to more pathways. And at each of those different no pathways, the bill is silent upon what they can do with that pet. So they get told a no. If they accept that no, how long do they have to have that pet no longer in the property? The bill doesn't say anything. We're saying 30 days would be appropriate. It gives them a month to try and find what they're going to do. If they do apply to NCAT to try and have that decision contended, again, the bill is silent on what happens in that situation. It might be a few months until the NCAT listing, and then it might be some time after that until they have a decision, if it's a deferred decision. So during that time where it is contested, what's going to happen to the pet? It can't stay in that property. We say the pet should stay there. It's already been there, and the bill is trying to create a situation where the pet is able to stay in the property until a definite no. So we think that we should just make it very clear that there isn't a definite no if it's still being contested and going through that process. So throughout all that, there should be a 30-day opportunity for the pet to remain in the property until it's resolved.
Thank you. I want to talk about particularly vulnerable groups of people, because I assume that a lot of these vulnerable people end up coming to the RSPCA in these situations, having to choose between potentially their home or an animal, particularly people with homelessness, or people, and you mentioned in your opening statement, people leaving violent situations. What sort of amendments do you think will really help them? I imagine one of the big issues would be that, if they get a no from the landlord, they may not necessarily want to go to NCAT. 30 days they may not be able to rehome their animal, or they may not be open to rehoming their animal. And so, what other things can we do, or what amendments can be put in to ensure that these vulnerable groups are protected in those situations?
Insofar as amendments to be made, some big ones that would help, I think, is to make sure that there is a penalty-free termination in a situation where they do get a final no. So if the end result of the process, either a long or a short one, is the pet can't stay there, they should be allowed to terminate and leave the property within a set time frame without having penalties applied to them. So that way they're not going to then have some huge financial burden pushing them to have their pet be rehomed, or to try and surrender it somewhere, or face these huge penalties of moving. I think some other things that would be really key with regard to what you're describing, though, and it's not even just people who are in the most extreme and desperate situations like leaving domestic violence or being homeless or anything like that. We at RSPCA and SWC, people right across the state, all walks of life, and everyone has got different levels of capacity themselves, and not everyone has got, you might say it's fair that everyone can just go to NCAT and just appeal it, but that's kind of like telling an elephant to climb a tree. For some people, it's just not going to happen, whether it be because of their level of education, their SEO background, and they just don't feel the confidence to stand up for themselves against professionals like real estate agents, or any number of other reasons, even just having the time to do it. I mean, if you're a parent or a single parent and you're navigating that system by yourself, it's a really exhausting thing, and we haven't quite gotten the message out there even to the professionals. I recently moved in October last year, which is a year after the laws were changed to allow pets to be friendly, and a very big strata company and a very big rental company both did not follow the law. I was told to pay $300 to pay for the application at Strata to be assessed, non-refundable, and luckily I know the Act very well, and so I could tell them why they couldn't do that. And the same when I wanted to get a pet, they said it will be every 6 months for a full clean and fumigation, and I said you can't do that, and I referred them to it. I'm in a very unique position where I can point to those parts of the law because I was very involved in the consultation for that legislation. Not everyone has that same benefit. Most people have a life, which is good for them, and they shouldn't have to. And I think that the biggest thing in all these reforms is the onus. So there's a huge onus on the tenant to know the Act, navigate NCAT, navigate the whole situation, stand up for themselves against professionals who are asserting things that might even be illegal or against the Act, but asserting them with great conviction. And that's just not really possible. I do think it would be far more straightforward to have the professionals in the industry, the practitioners, educated on what to do, and I do think it will be more appropriate that those same practitioners, the ones who have to go to NCAT to try and make a home not pet friendly if they so choose to do so with their landlord. And the education part of it in general, I think a lot more needs to get done, both with practitioners and the public, to make people have the confidence. So there's a lot of amendments in the submission. Some I've touched on, some are in there for taking. That would help, but if people don't know about those protections being there, they still feel like they need to try and surrender their pet because they keep on getting knocked back, and it's quite difficult to get an application, and it's one thing they can do that might just help them secure a home. And that is going to be a really emotional and tough decision to make, but people have to have a place to live.
Since the new laws came in that were proposed to be helping renters to actually have pets in their rental properties, has RSPCA seen any kind of drop in the number of surrenders for that reason, because they can't find a rental property, or is it the same?
No, we haven't. So it's maintained at a historically high level of around 20%, stating that is the reason, which is the best data to go off to see the impact, because our surrender wait list numbers fluctuate on a whole bunch of reasons, including internal ones like our current capacity or inspectorate seizures and all sorts of different things. So the actual percentage of people who are citing that as the primary reason or the sole reason hasn't really changed or fluctuated, which these things are not going to be an overnight change in circumstances, because people have already got leases and then they're going to sit those ones out. And as I say, it's about the education. Once they know, okay, I've got a system where I can get a pet, I can move with the pet, and I'm pretty protected, and I feel confidence in that system, that we're going to see those numbers hopefully ease down.
Thank you. I wanted to get a bit more information about the impact on shelters, rescues and pounds if these changes went through as they are. Do you think that we could potentially see an increase in abandonment or animals being killed in pounds because of that whole switch of a no, and suddenly that animal immediately has to be removed?
Yes, absolutely. If people are having to not face all sorts of fines and consequences for having the pet, they're going to try and get it out of their property quickly. That's going to lead to desperate situations of leaving it tied to a fence at a pound or an RSPCA, which happens all the time, leaving it out in a forest or abandoning it in a park, just letting it run stray, or trying to, those are the bad case scenarios. The better case scenario is actually bring it in and fill out the surrender form and potentially make a financial contribution to that, but that still then creates a huge intake problem where we've got more animals than ever needing to be rehomed, and that of course is going to lead to pressure across the system that will lead to increased euthanasia rates of animals that otherwise were in homes. And they had people who wanted to care for them. It was a great situation. We got a family with a pet, they're all going really well. There's no need to change anything that's being forced upon them because of rental laws or changes as they go through the system.
Thank you. One of the recommendations in your submission was that landlords or agents should be required to make certain disclosures in ads relevant to keeping an animal. Can you explain why you think that this is beneficial? And I guess it's beneficial both for renters and for landlords, so if you could take both perspectives.
Yeah, I come at this as a former real estate agent and a former landlord, and then also as a renter and from RSPCA, so I do try and take all these different sides of it into account, and I think that high turnover is bad for landlords and estate agents, properties and renters. So things that are a matter of fact, like if there is a cohabitation of the property that might not be clear, it might be a large acreage with two homes and you think that they're separate, but it's actually co-located properties, and therefore they could say the pet can't live there on that basis. That should be disclosed up front at the application stage to make sure that they know. I also think that if a property's gone to NCAT and they've had a successful decision to not have a pet at the property, the kind of pet and the reason why should be disclosed. So it might be a medium dog was prevented from being at this property in a previous decision because of the very rare irreplaceable Venetian tiles that would be otherwise scuffed. Okay, that might not apply to a cat, so then the cat can still take that into consideration, but we don't want a situation where a landlord has, continually having people move in with a dog and then having them move out with that dog because of this particular property not being pet friendly, and it should get disclosed. And those are the ones that are actual matters of fact that should get disclosed. That should be the limit of it. We shouldn't have the ability for agents, in my opinion, to say, we can't say no pets, but this one you definitely wouldn't be able to have a pet because it's got this, because they may mislead people in that process when it's not a matter of fact. Mm-hmm. I also did have one other thought after I put this submission in. I actually had it this morning walking over here. People often get the rental references from agents through the application website, and so the renter does not actually see what is said about them from their current landlord and what goes to the new landlord. It would be normal practice at the moment that a agent would disclose if they've got a pet in that reference. It might be a good thing saying they look after their pet really well and there's no problems, but even that is going to currently be a loophole that is not closed, where the person might then go, oh, okay, well now we found out they have a pet and we don't like that. And so even a good pet owner is then having information disclosed about them. So there needs to be also an amendment which says that estate agents or those providing references in any form don't disclose information about pets to the applicating agent.
Thank you. In your submission, you made a whole lot of recommendations about how the bill could be improved in the confines of the current regime, and I note obviously that you've already discussed a little bit about some of those amendments, and you've also discussed about some of the bigger problems that are caused by the bill in the first place. But some of these are, allowing people to keep their animal at the property when they apply to NCAT. Some of the other ones in regards to data collection and measuring the operations of the reforms, supporting education, transparent reporting. Can you talk through some of your amendments and your primary amendments and why you think that they're really important?
I'd be very happy to, thank you. So the primary ones are all with regards to what to do if you get a no. So the very first no, they should have 30 days to apply to NCAT, or 30 days and the whole way through they should have 30 days to then be able to vacate without penalty. If they apply to NCAT while that's been happening, they should be able to have the pet there. If they end up with a decision that the pet can't be there following NCAT, they should then have another 30 days to either find a new home for the pet or to vacate the property. So that gives them absolute security throughout the entire process to keep the pet in the home. We already barely in our crisis support programs can cover those who are homeless or experiencing domestic violence. Adding a new criteria of a crisis program, a short-term stint of caring for a pet, it would just be impossible to meet demand. and be a really difficult situation where they end up getting a yes, but through the process they couldn't have had the pets. They've already surrendered it somewhere, and it might have been rehomed, it might have gotten put down. That would be just a terrible consequence that was entirely avoidable. And I would note at the outset, with landlords are protected through the Residential Tenancies Act to always have the ability that the tenant has to make good. So they've already got a protection that makes the property come back to them as it is, or as it was given to that tenant. Otherwise, they're going to face financial penalties. You don't have to then have a whole bunch of other regulations and rules around ensuring that happens anyway. You can always repair a property at a cost, and the cost, if it's the fault of the tenant, should fall to them. It's much harder to replace an animal that's gotten put down during the process of flying through NCAT. So let's protect the things that aren't replaceable, and the landlords are already protected throughout the process. With regards to data, if you don't measure it, you can't improve it. We have no idea how many people are currently applying for a pet and getting a yes or a no, and the reason for those no's. I just think that Service NSW are very well placed to be able to capture that data, so we can have a look at it and see these reforms that are already in place might be working really well, or they might not be, and we wouldn't know. And so how can we possibly make more changes to it or improve it down the track? When you do rent a property, you go through registering a bond, and I was thinking about it and I thought, you've already got the estate agent or landlord having their email address, which is a service email address on their end, and then the same thing for the tenant. That would be a very appropriate online and therefore measurable place to have them apply for the pet, and for them to be able to assess it and come back with an answer. And that way the applications and the answer would all be recorded digitally, and we could then have an export every quarter of what's taken place in the market to know how many applications there are, what the outcomes are, and the reasons for those outcomes. I think that'll be just a no-brainer to know that. I also think that enforcement, we don't currently have particularly hard enforcement on practitioners who might be misleading people who are applying or people who are in a rental property, and that needs to get changed for the very reason I experienced last October when I moved. They might have been ignorant to the reforms, or they might have an internal policy where they just try it on, and then if they can get the fee or get the conditions put in, hooray, and if they do push back, they'll just waive it. I would have no way of knowing, and there's no point really reporting them because nothing would even happen at the moment anyway. So that needs to change to try and help. Businesses want to make sure that their staff are educated, or it's going to face some sort of penalties. So that enforcement needs to get beefed up, and this current reform does a bit of that, but not entirely. And there also needs to be data collected about the enforcement, because we have no idea how many people are still facing a situation where they're being misinformed by a professional and taking that at face value without questioning it or looking up the Act, or how many are making complaints about them. We just don't know what's going on out there. So I think that there's some pretty obvious KPIs to measure to understand whether or not this is working.
Thank you. And I guess if we took on all the amendments that are proposed today and they passed, for example, do you still think that given the other issues that you've already raised in regards to sort of the current setup with the tenants having to go to NCAT, that we still really need to keep an eye on these reforms for any other unintended consequences once those amendments go through?
Yes, I think that collecting data about what is happening is always going to be something which will then help legislators make improvements to legislation. And I don't see why anyone would want to be in a decision-making position of power and not have all the information. So I think that when data is easily collectible and obtainable, it should be for the reason that I outlined, better improve the Act and make sure that it's working in the way that we want it to. It may also show that there are huge burdens being applied to practitioners and landlords, for all we know, that isn't currently being measured. It goes both ways of actually having the data and knowing how many applications are happening, how many are going to NCAT. Are we clogging up the NCAT system by having them all go straight there? Should there be a different pathway for these? We won't know any of that without collecting data, and the data won't lie. It's objective and would be helpful for all people involved in these discussions and for decision makers.
Thank you. Honourable Mark Buttigieg.
Thanks, Chair. Thanks, Mr. Wilkie, for appearing. I've just got a question about the Queensland model where renters are encouraged to discuss pets with their landlord before entering a lease. Have you got any commentary around the functionality of that?
Yeah, I mean, I would say that having that function just creates a situation where the landlord and their agent are then aware of the either intent or current circumstances with regards to pets for that tenant, and that creates, whether it be conscious or unconscious, biases towards those who may not have a pet. I totally understand that a landlord wants to minimise impact to their property. That is a very natural thing to want, and that some will think that having a pet there is going to cause the opposite, and they're going to have a bias towards those applying that don't have a pet. That's our current situation in this state, where you're having to disclose whether or not you have a pet, or even potentially intention of having a pet, and that's why we need this government bill does a very good job of making that at least silenced. That way the person can apply without that being a reason to accept or reject a person's application.
Predisposed bias, yeah.
Yeah.
And what about the, in terms of the form, the application form, asking specific questions about pets? What's your view on that?
Well, it shouldn't have it in there if we want to try and meet the objectives of the government's bill, which is that it is taken away from being a deciding factor for agents and for landlords. And I think having a standardised form is a no-brainer for a lot of other reasons that aren't really related to pets, but both in terms of privacy reforms. It's excellent to standardise that, and also for ease. If people can get used to filling out one particular form for each place they're applying for, that's going to make a lot less burden on tenants and people across the state.
Thank you.
Thank you. Honourable Aileen McDonald.
Good morning.
Right.
Good morning.
From a legal perspective, do you think the bill balances, say, tenants' rights, landlord rights and pet welfare considerations?
I wouldn't say that it balances them well.
Adequately balances.
Yeah, and that's why I'm trying to be fair-minded and objective in my answer, but I don't think I would be able to agree that it balances them well unless the onus was changed with regards to who has to apply to NCAT and navigate that system. I do find any legal process to be a challenging one, and I'm well placed to navigate it personally. So I think that there are many in our community that it's just not possible for, and I do think it's appropriate that the paid practitioner who is in that space and would be able to learn it properly as part of their certificates and their training in their place of work, be the one to do that rather than the onus being on the tenant. That aside, if that's just impossible, which it probably is, if we did pass amendments, all the amendments that are in the submission that take it as it is and put those through, I do think it then gets the balance right for a landlord to be able to assert a need to be able to say no to a pet in the circumstances which have already passed as being the reasons why. It takes away the ability to have a bias towards non-pet owners and applicants, and therefore it does get the balance right by and large if those protections are in place while navigating the NCAT process, whoever's the one with the onus of navigating it.
So in your submission, and you've basically clarified, the onus should sit with landlords to seek refusal through NCAT rather than
having to put an appeal through as the tenant. Just because I think of you've got to have a certificate to be a practicing real estate agent, and most properties are leased through that. It's a process that they'd be dealing with a lot in their job anyway, so they're very well placed to have that at least initial burden upon them rather than upon the tenant. It's even just easier to educate them. I mean, there might be tens of thousands of estate agents that have to get educated on how to navigate the process, whereas it's millions of renters in the state. So we're looking at going, well, who do we try and get across this detail and understanding of the system? It's much easier to educate the tens of thousands rather than the millions. So even just from that practical standpoint, it will be the appropriate mechanism.
And do you think allowing tenants to sign a lease before knowing whether their pet will be allowed creates, say, unnecessary risk?
I don't, given that there are defined reasons for refusing a pet. So we're effectively in a situation now, which is a good thing, that properties are pet friendly, bar for some very particular reasons. And it would be the minority of properties that fall into those particular reasons. So therefore, I think that by and large, most people will move in, apply, have a yes because the reasons for no are not appropriate for that property, and then be able to keep the pet. So I think it gets it right for the vast majority, and that's a great thing. I just have these concerns with regards to those who get a no and then have
only 7 days.
Well, they've got no time to then, from that no, to have the pet even in that property. That same day they have to try and have it out of the property or be in breach of their rental agreement, which isn't practical.
And so would allowing pets to remain whilst a tenant seeks that NCAT review prevent unnecessary surrender, do you think?
Yes, absolutely. As I was alluded to before, I'm particularly concerned about a situation where a person gets told no, and then that same day they have to try and have the pet not in their property anymore. And then it might be a few months later they finally get the yes through NCAT. And have they been able to secure that pet a place where they can then get it returned back to them, or has it already been rehomed or put down, or have they had to abandon it in less than ideal circumstances by leaving it in the park, tying up to a fence, those sorts of things. Which.
And I know you've already talked about, say, data collection, but how would you recommend that statewide data statewide data on pet applications? Would it be the applications and then also the outcomes, and then what gaps would you see in the current system?
Well, in the current
there
system,
isn't one.
I mean, there is no data collection at all, and the process is ad hoc. So it might be that a person's applying to have a pet in their property within 7 days of moving in via email. The estate agent might then say, we don't do emails, fill in our form, so there's no standardised form for applying for that pet. So the whole thing is completely ad hoc and no data is being collected. What I would suggest would be the best way I can think of it, and I'm not in the department, so it might not be the actual best way, but the best way I can think of it being done is through the bond portal, which is already going to have to get a huge revamp for the portable bond scheme to get implemented that everyone's on board with. In that portal, there should be, I want to apply for a pet, put in the information on a digital form of the characteristics of the pet or any other information about the pet, submit it, and then the decision is also delivered through that same portal, and the one of the 8 reasons for saying no or yes is recorded. And that would just give us an overall amount of how many pets and what kind of pets are people applying for, and then what's the outcome of them, yes, no, NCAT referral or not. And that would be a starting point to understand what impact this is actually having in the community.
And if, say, the RSPCA could only put one single amendment to the bill, what would you recommend to prevent, say, unintended consequences of the bill?
It would be one really big, long amendment that does all the things that are in my submission.
Okay.
I don't think you can have 28 days to hold the pet while deciding to apply to NCAT, and 30 days, and not have 30 days after the NCAT decision. I think all of them are about giving a 30-day, around 4-week window of going, okay, I got to know, what do I do from here? Do I move out or do I go to NCAT? And then going through the NCAT process, which obviously should be held, and then at the end of that process, whatever decision is made, being able to have a couple of weeks to make a decision about them, their property, their pet, and what's going on, I think is just appropriate for people. So, yeah.
Applicant?
Thank you. Is there anyone online that has some questions? Ms. Boyd or Mr. Primrose? Ms. Boyd?
Hello, and good morning to you, Mr. Wilkie. Apologies, I'm not there today. I'm feeling a bit under the weather.
I'm sorry to hear that.
I am at home with my pets, and I did put my hands up at the at your questions earlier.
Lovely.
I just wanted to ask you just one quick one. I understand that there was quite a bit of consultation on the bill prior to it being announced, and it has been put to us that there was some significant changes between the version that was consulted on and the version that was then made public or finally announced. Were you consulted on this bill, and did it change from the version you saw to what has ended up being released?
I mean, the consultation process is one that is of non-disclosure, but it's already been ventilated in the SMH just a week ago and a bunch of times before that there was a different version, and that there was changes made at the 11th hour to the bill that was passed in October of last year. 2 years ago. So I think that it's already public knowledge that there was a different bill contemplated and consulted upon that did have some changes made to it.
Thank you. And the RSPCA signed a non-disclosure agreement. Then is that a?
I don't think I signed one. I think it's just the way that they, in the distribution of things, you get told, this is being sent, with some confidentiality. So have a look at it, provide feedback, and that's a really important part of the whole process. So that way, no one's getting on either side our feedback or things that are being contemplated by the government of the day. It's pretty standard that there's sort of confidentiality agreements with that. But as I say, I don't think I'm creating any real headlines for anyone to say that yes, there was versions that were consulted upon, and then there was a different version that was put through the houses.
Your actual feedback, though, on that bill, is that also subject to an understanding of confidentiality, or is it just? I mean, I understand,
Yeah.
If you've been given a version ahead of time, that it's a sort of given to you to get not for you to go and disclose it to the media, but to get your feedback. But is your feedback then also confidential? Are there any restrictions on what you can then talk about in terms of what you have said?
I'm not a lawyer. I'd have to take that on notice if you really wanted the right answer and talk to a lawyer, because I'm not sure. We don't really say this is confidential and it's our points of view. But overall, the process, I think, does work best when there is an element of confidentiality and you can then have a more robust discussion. But that being said, we've then separately, as with this submission, given public feedback with regards to these reforms. And I think that the biggest change we would make to the reforms that have already come and to the reforms that are forthcoming is who we're putting the onus on to try and navigate the NCAT system and have that burden. And that's the big one that we could fix, that would really alleviate millions of people from knowing about and learning about and navigating a complex system versus the actual professionals and practitioners in the sector that are in the tens of thousands.
And so that is the major change that sort of differed from the version you were consulted on to the version that was then put out, as has been reported?
I would say that's the major change that we've continually been advocating for across the process, that you would try and minimise the number of people that have to have an in-depth awareness of the legislation and navigate that legal process through NCAT or otherwise.
Thank you, and thank you for your submission. I think your recommendations are excellent. That's all I have for now, Chair.
Thank you.
Thank you. I just have another question. You were talking before about being able to look at this sort of from a point of view of landlords, point of view of tenant, and also point of view of the animal welfare. I wondered if the bill passed as it is, without the amendments through, do you think that there's a risk that tenants will feel that it's safer not to declare that they've got animals and actually sort of hide them in the properties due to the fact that there is so much uncertainty if the landlord says no?
Yes, absolutely. And that's already happening, and it raises a great point about I do think that landlords should know about who is occupying their property, including animals, and a lot of them are currently being misled because people are fearful of what will happen if it is disclosed. So that creates a whole bunch of problems for the landlord later on to try and assess damage on the property, and that they've been aware about a pet being there, and all sorts of different issues there. It also creates problems because if people aren't telling their landlord about their pet, they don't really want to go and then register it with OLG on the pet register because they don't want to have it put down on their name, and then we've got these unregistered pets that are going missing or stray, and then they're not getting returned to their owners. Like, if people are doing, for a whole bunch of reasons, people are keeping their pet a secret, that they want to keep it a secret from everyone in authority positions, that can have unintended consequences. So to best protect landlords, you want to have a system that is fair and balanced, so that way people are going to be able to be open about it and say, yep, I have got a pet and I've now moved in and I want to apply for it, and here are the details of the pet. Or people who might have disclosed one pet and actually have 3 or 4. Again, that changes what a landlord knows about the property, and it changes what decisions they could make as a landlord. But people are there's currently such a huge imbalance. People are going to mislead their agent and their landlord because they just feel like they have to.
And I guess the other one, just for clarification, I guess, we had, this bill has come in tranches, and so we had a first bill which is already passed, which is kind of defined who will go to the tribunal, whether that's the landlord or the tenant, and that bill passed, and so it will be the tenant that has to apply to NCAT. Now we've got this bill which proposes that, or one part of sort of a regulation within it would be that landlords can't ask about pets on an application, which you support, I assume.
That's right, yes.
Yeah. And then there's sort of some complications around that, because then the tenant would have to actually apply for the animal once they move in. Do you think that the amendments that you have proposed, if most of them passed, or the key ones really passed, do you think that overcomes some of the tribunal issues within the first bill? Or do you think it's sort of it's a case of, if this passes, let's see if that solves a problem and creates a balance, and that sort of goes back to your sort of data points?
No, I think the amendments that we've put forward give the best possible implementation for the reforms as they stand, both the existing ones and these current ones, and we'll never get in the way or say that we shouldn't pass reforms that will improve the situation. But we don't want to have the perfect be the enemy of the better. But in saying that, it would be far and away, I think we should be looking at the situation going, okay, like what they do with commercial tenancies. They sign up and they say, I have a responsibility to return this in the same condition or better than I got it. They then take that responsibility and use the property however they really see fit, and then at the end of it, they return it and it all gets sorted out. That is how residential leases could also operate, and therefore you could have it up to the person who has taken on that responsibility of leasing the property, have responsibility for their pets, their guests, their kids, whoever comes into the property. I mean, they're just as responsible for a potential bottle of red wine that gets spilled on some white carpet as they are for their pet. And that's why I do say that landlords are really well protected by the make good. And if they aren't being well protected by that, reform that, because they should be protected by that for all of the potential known and unknown risks that come with somebody else occupying the property. It does need to be that the person who signs that document has responsibility for the property to return it in the condition that they got it, despite reasonable wear and tear, and that's got to be the protection for landlords, not a whole bunch of other, red tape and rules.
Well, thank you. And thank you for coming here to give evidence today. We appreciate your time. Because we've got such a tight timeline as a committee in regards to when this bill will come up and when we will be reporting on it, there's going to be a very limited window for any questions that are taken on notice. I don't think you have taken any questions on notice today, which is good. However, there may be some questions still on notice. However, I can advise that the committee has resolved that transcript corrections, answers to questions on notice or clarifications to any evidence that you gave today, and any additional information that you want to provide would be within 24 hours on receipt of the transcript to witnesses. But the Secretary will be in contact in relation to any questions and provide you of a transcript of today's hearing in the near future. Thank you again for your time.
Thank you.
Thank you, and I welcome our next witnesses. Could I begin by asking each witness, starting from my left, and I'll start with the witnesses in the room and then I'll go to Ms Ward online. Could I ask you to please state your name, position, title, and swear either an oath or an affirmation?
Yeah, Samuel Davis. I'm here as the Vice President of Animal Care Australia, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Stephen Albin, CEO of the Animal Welfare League, New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Ms Ward? Oh, sorry, you're on mute, Ms Ward.
Thank you. Tara Ward, Volunteer Managing Solicitor with the Animal Defenders Office. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you. I'm now opening up for short statements. Does Animal Care Australia have a short statement they'd like to make?
We do, thank you. So thank you for the opportunity to present to the committee. In my role as VP of Animal Care Australia, I've attended a range of meetings, compiled numerous submissions regarding pets in strata and in rentals. In 2025, the reforms aim to normalise and simplify pet keeping for rental properties in New South Wales. ACA argued unsuccessfully, as did I think a lot of other organisations, for a default consent, with the landlord needing to provide evidence to remove consent. Unfortunately, this position was not supported by the government, which has resulted in the issues this bill is attempting to overcome. Regarding pets in rentals, the bill aims to ensure the statutory process for keeping pets in existing tenancies is applied equally to new tenancies. ACA supports the amendments proposed by Emma Hurst, AJP, which resolve issues should an application to keep a pet be rejected after a new lease has been signed. The remaining problem is to prevent exclusion of applicants with pets at the rental application stage. A few practical examples illustrate the problem. On domain.com.au on Saturday, just 2 days ago, there were 10,518 properties offered for rent in the Sydney region. Of these, just 948 landlords and agents had ticked pets allowed, less than 9%. This does not reflect the intent of the statutory process, and whether or not that should be continue to be permitted to have such a tick box, I'm not sure. Rental application forms also routinely ask applicants whether they have pets. This allows agents to exclude those applicants before any statutory process can occur. Just an example, a Central Coast solicitor friend of mine provides a good example. She has a small dog that looks much more like a teddy bear than puppy. She was asked and did disclose her dog on her first 6 rental applications and was refused each time. On the 7th application, she did not disclose the dog and was immediately accepted. I personally own a number of investment properties, and Maddie, my friend, would be the absolute ideal tenant. As ACA, we have many other examples, although it's a little difficult and to actually work out, well, why exactly were they culled, where I think that case it's absolutely clear. Animal Care Australia recommends that the legislation explicitly prohibit rental application forms and hopefully, not sure how to do it though, and property advertising from including pet restrictions or questions about pets, unless a tribunal-approved restriction applies to that specific property. One final tweak is to ensure the statutory process for applying to keep a pet can only commence after a lease has been signed, not during the rental application stage. We encourage Parliament to ensure the statutory process for keeping pets in existing tenancies is applied equally to new tenancies. Many thanks for your attention.
Thank you. Does the Animal Welfare League have an opening statement?
Yes, we do. Chair and members of the committee, thank you for the opportunity for Animal Welfare League New South Wales to appear before this committee today. We've been caring for animals and supporting responsible pet ownership for more than 65 years. Each year we assist tens of thousands of animals across New South Wales through our shelters, vet services, rehoming programs and community outreach services. One of the most common and preventable reasons animals come into our care is housing insecurity. When people can't find rental accommodation that will accept pets, they're often forced to surrender much-loved companion animals. This is distressing for families, harmful for animals, and places additional pressures on the animal welfare sector. Animal Welfare League New South Wales welcome the reforms made to the Residential Tenancies Act 2010 New South Wales in recent years, which modernised tenancy law and improved the balance between tenants and landlords. In particular, we welcome the introduction of clearer processes around keeping pets in rental housing, including requirements for landlords to consider pet requests more reasonably and the establishment of clearer pathways for tenants to seek approval. These changes recognise the reality that companion animals are an important part of family life and that responsible pet ownership should be compatible with renting. The reforms represented an important step forward in reducing unnecessary pet surrender and improving housing stability for many renters with animals. The committee is now considering the Residential Tenancies Amendment Protection of Personal Information Bill 2025, which addresses another growing issue in the rental market, the handling of personal information in the application process. Rental application systems increasingly require prospective tenants to provide significant amounts of personal information, often through third-party digital platforms. Many applicants submit multiple applications while searching for housing, which means sensitive personal information can be collected and stored across numerous platforms. Strengthening protections around how this information is collected, stored and used is an important step in ensuring that the rental application process remains fair, transparent and secure. For renters who have companion animals, this is particularly important. They're often competing for a smaller pool of available properties and may need to apply for many homes before securing accommodation. Ensuring their personal information is appropriately protected helps maintain trust in the system and reduces unnecessary barriers in the housing market. Animal Welfare League New South Wales supports reforms that improve fairness and transparency in the rental process while continuing the positive direction of the earlier tenancy reforms. Ultimately, policies that improve access to rental housing, including fair application processes and reasonable treatment of tenants with pets, help keep families and their companion animals together and reduce the number of animals surrendered to shelters. We look forward to contributing constructively to the committee's work and we're pleased to answer any questions.
Thank you. Animal Defender's Office, do you have an opening statement?
Yes, thank you. The Animal Defender's Office both welcomes and laments the opportunity to comment on the Residential Tenancies Amendment Protection of Personal Information Bill 2025. The bill is welcome because it recognises that there are fundamental problems with the current framework regulating the keeping of animals in rental premises. Unfortunately, however, the bill is a bit like using a band-aid to fix a broken leg. In short, New South Wales went with a defective model when it chose an animals not welcome until landlord consents approach to pets in rental premises. It is not surprising that the model has been operational for less than a year and it already needs fixing. Over the border, the ACT introduced a pets welcome at any time until tribunal approves a refusal approach in 2019, and it has worked well with no changes required since its introduction. While the Animal Defenders Office welcomes the New South Wales Bill's attempts to grapple with the inevitable problems of animals not being allowed until consent is given by the landlord or by the tribunal via a tenant application, we fear it will not be the last such band-aid, and no amount of band-aids will fix what is essentially the wrong model. Thank you.
Thank you. I've got a few questions, and I suppose some of these questions are framed around the idea of that we've got this current bill before us, and how do we kind of fix the current bill as best as possible if it were to pass. I've got a question that's probably best directed both to Animal Care Australia and ADO. I just wanted to get you both to talk about the need for penalty-free terminations if someone is refused to have an animal. So somebody moves into a property, they've brought their animal with them, the landlord has said no for some reason, and they've got what is listed as a genuine reason for saying no. Why is it important that then we have a penalty-free termination option for that renter if they want to leave with the animal? And I might start with you, Mr. Davis.
Yeah, no, I totally agree that has to be the case. I'll just say first up, I do think that the reforms last year mean that that's probably a very difficult thing to actually take place, and it's probably going to be more the exception rather than the rule. But nevertheless, obviously, if somebody's just commenced a lease, then there has to be a mechanism for them to get out of that lease, and to also have sufficient time to find another property, and another property that's, I guess, going to be willing to take their pet or their animals with them. So totally agree, and I think actually what the AGP amendments have got in there is very detailed and deals with that well.
Thank you. Ms. Ward?
Thank you. Yes, I would agree with that. I mean, these regulatory frameworks dealing with residential tenancies already contemplate situations where tenancies can be terminated early by tenants. And it would simply be a question of adding this situation to one of the already accepted situations or circumstances where a residential tenancy agreement can be ended early. So it's, it should really be, and it's required from a practical perspective, sorry, that's what I wanted to add. It's required from a practical perspective because animals are complicated, especially if there may be more than one. And it's not easy, as we've already been hearing, and one presumes you will continue to hear throughout the day. It is difficult it can be very difficult to rehome animals. So there needs to be that situation that would allow the keeper of the animal to move premises in those situations where it's not straightforward, and certainly they wouldn't want to be separated from their animal, who we recognise are now members of the family in many circumstances. Thank you.
Thank you. My key concern around this bill really is that, we're going to see a situation where a renter will apply for a property, they'll sign a 12-month lease, they'll go to the cost of moving in, they'll apply for their animal within that 7-day grace period, the application's refused, and then essentially whatever they decide to do at that point, they have to figure out what to do with their animal immediately on the spot. Whether they break the lease and incur the costs of finding a new property and move, which is probably not something that's not available to many people on the rental market. Whether they try to rehome the animal. We heard this morning from the RSPCA that was nearly impossible to do at the moment with shelters and pounds already over capacity. I guess I just wanted to get the thoughts of each of you, sort of, how do we overcome those situations, and particularly for people who are particularly vulnerable, people who are living violent situations, for example. I know in your submissions, you gave a few examples of amendments that you'd like to see to help protect those individuals. I just wanted to spend some time just going through some of those amendments and how each of those amendments could work potentially to soften some of the concerns that are coming up with that bill. I might start with you, Mr. Davis.
Yeah, again, I think maybe one addition that I suspect wasn't in your amendments, and I haven't got them in front of me because we basically in our submission just said, please government do what the AJP said in this case, which is a little unusual for our organisation, but we're certainly in parallel here. But I think if there's one thing that comes to mind is we've got a process already for landlords to go and get a ruling from the tribunal if their property is not appropriate for pets for whatever reason. Maybe the landlord lives in the property, or maybe there's even a boundary issue, so it might be on a rural property, so horses or livestock or something are not appropriate, or a range of other reasons, although and most of those reasons, to be honest, are very specific to the property. So perhaps we could sort of, that's a reasonable thing, and maybe it needs to be there up front as part of the application process, that the tribunal, and they need to go and get that ruling from the tribunal first. And then, so that then there's a lot more surety once people actually move in with their pets, so that we don't have to go through this whole mess of people being refused and so on, which I know it's possible, but I do think, I hope, under the current regime, that's the sort of 1 in 1,000 that we, probably there's situations, to be honest, that we haven't thought of to put in.
Definitely. Mr. Albert?
So, Chair, I just want to clarify, are we talking about the Protection of Personal Information Bill, or are we talking about the other bill as well?
We're talking about the Protection of Personal Information Bill. The other bill has come up a little bit, I suppose, because a lot of people have highlighted that the previous bill, which is linked to this bill, created a situation where the tenant has to go to the tribunal instead of the landlord. And then that has created the reason for this bill to come forward. And this bill really is proposing, as one part of this bill, there's a proposal that when you're applying to go into a rental accommodation, that you don't have to declare that you've got an animal, which is, on the face of it, very widely supported, but there's no sort of guidance within the bill as to what happens if the landlord then says no, under the many reasons that were listed in the previous bill. So the two bills are sort of linked.
Well, look, thank you. With this bill and what Mr. Buttigieg said in introducing this as well, I actually think that the government, they're doing the right thing, that they think they're doing the right thing, and they are doing the right thing in ensuring that the private information of people who have pets is not shared, and they don't have to disclose up front. But what it does is it shines a light on that second, the initial piece of legislation, which was changing the Residential Tenancies Act. So, and that's where it becomes a material issue. I was formerly, for a decade, I was the CEO of the Urban Development Institute of Australia. I was on the board for another 6 years. I was on Fair Trading's Property Services Advisory Group, appointed by Anthony Roberts for many years. And I looked at the scenarios and tried to work out exactly how if bringing this bill in and looking at the second lot of amendments, if that would make a material difference. And it really, so it just say, for instance, if I said the landlord should go and be required to go to NCAT because they're the group that can bear that burden better, I think that's the only explanation I can give. But if you look at the outcome of that, it's going to be no different than where they sit at the moment. And where the tenants will sit at the moment. So this is a very, very difficult policy challenge, and it's a bit of a policy hazard as well. So in terms of solutions, I find it really hard to come up with a solution to this matter. Sure, you can go for the Victorian model, and I think that was in our submission. You can go for the ACT model, which the Animal Defenders Office talks about. But this is highly, highly complex, and every scenario that I run through, it's not a straightforward answer. Possibly education at the front end will help. So that is when people apply, they know the grounds of the grounds for which they can get rejected, which are clearly in that initial legislation. But besides an education campaign and potentially making the landlord have to apply to NCAT, it's very complicated to solve.
Yeah.
And unintentional, by the way. I think everyone thought they were doing the right thing.
Before I jump to Ms Ward for a further answer to my other question, we heard this morning from the RSPCA that in the 1 year since the last bill has implemented that they haven't seen any reduction in the number of animals surrendered because they can't enter the rental market with those animals. Have you seen the same at the Animal Welfare League, or have you noticed any difference?
Ours is distorted because of our increase in inspectorate work. So we've had issues with regards to surrenders. Okay. We haven't seen any major change in lines though.
Okay.
So I wouldn't, I don't think it's, I agree with the RSPCA on that matter.
Thank you. Ms Ward?
Thank you. I think in terms of solutions, this is the problem. Are we talking band-aids or are we talking fundamental changes? I don't think that that tinkering with the current model is ever going to get us to a good place, such as where a jurisdiction such as the ACT is, where it introduced a fundamentally different model, some 7 years ago now, and that's been working well and has not required a single change to the provision in the relevant act. This one, less than a year as we've already mentioned, and it's already requiring these changes to try to rebalance and make it fairer for some of the parties in these agreements, i.e. tenants, and of course the animals. The bill does fall short. It's going to require more changes. I think that's a fairly sort of safe prediction. One of the things that I think we discussed in our submission was, while it's good to focus on the start of a residential sort of tenancy period, and animals who may come in with the tenant to the new premises. However, what happens when sometime into the tenancy agreement period, the tenant acquires by some way an animal? It could be through rescuing the animal, it could be through inheriting the animal from a deceased relative. There are a number, and of course it could be actively going and seeking out and hopefully adopting an animal, worst case scenario purchasing. A purpose-bred animal. But what happens then? Do these provisions that apply at the start of the residential tenancy period apply in that situation? What's the time frame there? So that's why we've suggested that some changes a change that could be made is simply to broaden the application of this period. Now, several submissions made the point that 7 days is not long enough, and we would agree with that. So whatever period is ultimately agreed upon as being appropriate, at least 14 days, for a tenant to apply for the consent, since that is the current New South Wales model. From the point of, it could be worded in such a way as, say, acquiring the animal or coming into possession of the animal. And that at least would deal with this situation where after the commencement of the agreement period, the tenant comes into possession of an animal and wishes to keep an animal in the premises. There is, of course, other issues which many submissions have focused on. The fact that it doesn't deal with where the tenant does have to go to the tribunal. If the landlord or the lessor's first response is to refuse consent, that is just a no-brainer. Then the bill must take that into consideration. So just focusing on that one proposed reform of allowing the tenant to keep the animal while applying, that needs to be broadened both to the whole tenancy period and seeking review of or going to the tribunal about a refusal to consent.
Thank you. I've just got a follow-up question on that one. just looking at this kind of more broadly, and the suggestion that you have in regards to being able to apply for an animal at any point during the lease, and having that grace period potentially to have the animal. And I understand the situation that you give in regards to, you know, the death of a relative, for example, and so that animal suddenly comes into that person's care. But what about a situation, I mean, if that is put into the lease sort of midway point, does that encourage people to go and get an animal when they don't have a secure home for that animal? And then if those people are refused to have those animals, that we could see an increase in dumping and surrender potentially if a lot of those people are given a no?
Can I? Sorry, did you want to talk?
I'll ask Ms Ward first, but
Yeah,
if you've got an
sorry.
answer, I'll throw to you next. Thank you.
Sorry.
Thank you. Well, I think we have to recognise, sorry, this is not getting to your immediate point, but we have to recognise that people will come into possession of animals other than by choice, by actively going and seeking them out. However, the situation that you mention where, or the hypothetical, could it encourage people to acquire animals where they don't have stable accommodation? That is a bit of a, I mean, it's a real problem if the default position for rental premises in New South Wales, because of this sort of defaulting to not being able to keep the animals until the landlord or lessor consents, would mean that rental premises in New South Wales are by default not stable accommodation. And I think that's a real problem, and that has to be acknowledged and sort of dealt with. So if that's how we want to characterise it, otherwise we characterise it as, well, housing is stable because we have this model, such as it is, in place in New South Wales, where you may ultimately be able to keep the animal. You just have to go through this process first, which we of course don't think is anywhere near optimal. But I'm not. Hopefully, we wouldn't characterise it as that situation where people are being encouraged to go out and get accommodation where they really are in unstable accommodation, certainly there's, from one perspective, that is how you could characterise the current New South Wales model, which is regrettable.
Mr Davis, you had further?
I was just going to say, when we, over many years and in other states as well, talking about this issue, we go down this road sometimes of sort of treating rental properties differently in terms of animal welfare and people in rental properties to those who own their own property or in other types of accommodation. And I think that's a mistake. As much as obviously Animal Care Australia, we care about animal welfare, we absolutely do. But there are a whole set of rules and you know, obviously and laws and statutory processes and so on that govern animal welfare. This is not about animal welfare, this is about rental properties specifically. So I wouldn't like to go down a track where there's sort of some rules put in that affect how changes the nature of the rules in terms of animal welfare for people in rentals compared to landlords. I think that'd be the wrong track to go. I do think overall the issue here to me is quite straightforward. We put in place, and I think everybody supported it, the Parliament supported it, a statutory process for working out whether a landlord consents or doesn't consent to an animal, and we've got quite strict rules, and that I think, although there's probably some tweaking about the regulations and things for people who are in existing rentals, the problem is, and I think during the consultation that I've been in, and same in other states, ACT obviously got around it by doing what I think we all recommended, having a default acceptance of animals, but we haven't fixed that for new rentals. It's just really that problem that new rentals should have to abide by the same rules, and at the moment they can get around it by simply asking in some sort of application form or an implication in an ad or something, and I think that really is the guts of the problem that I would hope that this bill can put a band-aid on. I agree with Ms Ward that it is a band-aid. It would be far simpler if we just had a default that you can keep animals, and if there's a specific property that where they're not appropriate, well, that's up to the landlord to get a tribunal ruling that says that. Otherwise, there's just not an issue. But I suspect that's not realistic. So I suspect the best way to do it is to make sure, and I know there's mention of this application form in the bill, but I think it needs to be stronger. I think it needs to be in the actual act that you cannot. I think pet information is personal information, so it comes nicely under this Protection of Personal Information Bill. And I think that it should be that you simply cannot ask for that on the application. It's not relevant. The only thing that's relevant is the person able to pay the rent, and are they able to pay the bond? And is whatever's going to happen in that property, does the landlord feel that they're going to be able to pay for it? And is there a good, high probability that whatever that person does is going to wreck the property to the point that it can't be repaired, or that the bond, or that the person's not going to be able to repair? That's what you're looking at as a landlord. Whether they've got little kids, or whether they've got teenagers, or whether they're going to have parties, or whether they drink red wine, or whether they have a pet and so on, it really is beside the point. And we need to remove it at the application stage as well.
Thank you. The Honourable Aileen McDonald? Yeah.
Dreaming there. I'll ask the same question that I asked RSPCA. So from a legal perspective, do you think the bill adequately balances, say, tenants' rights, landlord rights and pet welfare considerations? And I'll ask all.
I think it does. We had consultations, and I think that there's a lot of stakeholders in this whole policy transaction. I think they all have grounds to be treated equitably. The landlord does require protections. The tenant definitely requires protections. And I think at the end of the day, when we went through that consultation process, and yeah, they were confidential, but as we were going through that process, that's where I think we changed a little bit in terms of understanding what Real Estate Institute in New South Wales wanted and others wanted, to ensure that we could get this through. I think there is a balance, I think one of the key issues here, though, and I'm not a lawyer either, by the way, I should say that, but one of the key issues is that the landlord can't unreasonably withhold consent, and there's a whole lot of tests there. But when someone goes to apply, how are they going to know whether or apply to rent a property? How are they actually going to know whether or not the fence is a certain height, it isn't damaged, which could cause problems down the track, which is why I said an education program might be the way to go at the front end. But I think it has required balance to get everyone's support, and I think it did that in the end. I don't know, you were there too, Samuel. So.
Yeah, there was a bunch of us, and actually, I think those meetings with the rental commissioner this is a rare thing for me to say, was actually really positive. Mm-hmm. It was a really good process, and it worked really well. And although the government didn't agree with, I think, in general, what we were saying, which was to have a default position that pets can be kept, I think what we've come up with, or what came out the other end, is a vast improvement on what came before. And all we're trying to do now, I think, is just tweak a little bit of a few things, which is that application. I kind of, like, I'm a landlord myself, I own a couple of investment properties, and I kind of get that view that, like, and we grappled with it. How can you allow, because the reality is, for me, if somebody has a pet, I'd probably prefer them. I'd think, well, they're probably a more sort of balanced person and caring person, and I'd be the opposite. But the stats that I see and what I quoted from domain.com.au seem to indicate that that's not the normal situation. For whatever reason, real estate agent forms and even that domain.com somehow are still in this idea that allowing pets is sort of a special thing. And I believe that is absolutely not community expectations. I think community expectations these days are that pets are part of a family and that they should by default be allowed in. So I think we need to sort of fix that application form stage, and I guess inform people who are putting in those applications that they no longer you do not need to tell. It's not relevant for you to have to tell the landlord that you have a pet.
And Ms. Ward?
Thank you. I would, in my view, the current framework in New South Wales doesn't get the balance right. I think that's inevitable with any model or framework where the onus is on the tenant to have to go to the tribunal. We do a lot of tribunal matters with the ADO, and they're stressful, they're time consuming, and they're very stressful. And they're long. I think it's already been mentioned, they can drag out. So any model that puts that onus on tenants, and of course tenants come from an infinite variety of backgrounds, but many tenants would find the whole prospect of going to the tribunal to quite or very intimidating. So any model that puts the onus on the tenant to have to do that, as coming from the ACT, we can again look at our model that's been in place for since 2019 without any further changes. Now, if landlords had serious problems, or lessors had serious problems with that model, they could have lobbied for changes to the framework as well. But clearly that hasn't happened. So I would point to the ACT as a jurisdiction where the balance is more appropriate and takes into account the needs of tenants, landlords and the animals. Any system that may increase the number of animals who end up in pounds or rescue organisations, there is something wrong with that model, and it has not got the balance right. As we've heard ad nauseum, unfortunately, our rescue, the rescue sector is beyond crisis point, beyond breaking point. Even the ADO, the little ADO, we hear from rescuers who are beyond their wits' end at how desperate the situation is out there for trying to rescue and save animals who have been abandoned or surrendered. We must have a system that reduces the incidence or the likelihood of animals being surrendered or abandoned.
Thank you. And so will, and you say they haven't got the balance quite right, so do you think the provisions in the bill reduce the number of pets surrendered, say due to inability to get housing or the housing issues, or are further reforms required? Sorry, Ms. Ward.
Yeah,
Thank
maybe.
you.
I can
Thank you. Just very quickly, well, I think one of the big problems is this fact or this proposition that the bill currently doesn't deal with that situation that we've already discussed, where the tenant comes into possession of an animal or wishes to keep an animal partway through a tenancy agreement. So it could be that the person simply has to say no. So reducing the options for rehoming animals is not a good thing. It's a terrible thing right now. We need to be increasing the options for rehoming animals. So anything that can be done to enable people to keep animals should be preferred. And I think that is a problem with the current bill. That it is silent as to coming into possession with animals midway or partway through a tenancy agreement.
Mr. Davis.
I was just going to say, back harping on my new applicants issue. it wouldn't be surprising that there's been no change since this new bill, because it doesn't assist new applicants, particularly those who have got pets and are fleeing issues, domestic violence or other sorts of harassment or homelessness or whatever. They're basically they've got to stay where they are, because at the moment they are asked on their application, and the information that we have from, admittedly maybe a biased sample, but the people who contact us, that they are getting refused. They're getting refused. Well, they're not getting refused. They're not getting progressed, I guess is the point. A landlord or a real estate agent sits with a pile of applications, and at the moment they just simply cull all the ones that have got pets. They just cull them. Maybe they don't even pass them on to, they pick, I know real estate agents I deal with, they'll give me the few that they recommend. And I'm not even sure, to be perfectly honest, whether my own real estate agent, if my rental came up, is not doing that already. I hope not. I'd certainly hope that they wouldn't do that. But that appears to be what's happening currently. So as soon as they see pet, they're not even in the running. They're put to the bottom of the pile immediately. So we can't expect that the bill from last year that was passed is going to solve the domestic violence issue.
I might allow others because you've got shorter time, so thank you.
Oh, yeah.
Yep.
Okay, thanks. The Honourable Mike Buttigieg?
Oh, fine, thanks, Chair.
Thank you. I'll check if anyone online. Ms Abigail Boyd, did you have any questions?
No, I'm okay. Thank you, Chair.
Thank you. Did you have further questions?
I
then?
did. Just on Mr. Davis, you said you would, like from your own personal view, if someone was a pet owner, you would probably look more favourably. So would you see that the law should move toward a default position that pets are allowed unless landlords, go to NCAT and object? Yeah.
Absolutely, and I believe that's the ACT model,
Yeah.
and that I think it's fair to say was the consensus of the people who were consulting with the rental commissioner, I think, during all those meetings. But we were let know without saying too much, because I get that it was in confidence. But that was not the decision of the government at the time. So we then started exploring this other way of where, you sort of, the tenant still had to apply for consent. But I believe you'd have a lot simpler legislative regime if it was turned around, and if a premises is not suitable for pets, and there are some examples, sometimes when the landlord lives there and they're allergic to cats or something, or maybe there's some fencing issues and so on, then that I think it makes much more sense to put that as a responsibility of the landlord to go and get that sort of certified somehow. It could be a relatively simple process in most of the cases, and then by all means that can be put on the adverts and so on, that the tribunal has said that no pets are allowed for whatever the reason is. But at the moment, having it the opposite way around, unfortunately, isn't working in my view for new applicants.
Oh, sorry.
You wanted to comment? Yep, sorry.
No.
No? Or is there a reform that could protect, say, renters' personal information while also providing certainty to landlords?
I think we sort of went, maybe Steve can feel it, we talked round and round in circles about this in the meetings to try to work out a way, and that's why, because I kind of get that it's a bit harsh to say nobody can ask about pets until the lease is signed. I kind of get that. But unfortunately, I don't know that there's any other option if you're not going to go to this default assumption that you can have pets, because it's absolutely clear from the people that have contacted Animal Care Australia, and I think it's probably fair to say for other people who are providing evidence, that landlords and agents are culling applicants simply because they have pets. And I believe that is not what society demands. I think that's wrong. And unfortunately that means for the people like me, where I'd probably go the other way if I saw an applicant with a pet and perhaps put them to the top of the pile. Unfortunately, the evidence that we're aware of shows the opposite is actually the case.
Ms Abigail Boyd?
Yeah, thank you. Mr. Davis, something you were saying earlier I found very compelling. You were saying about basically, you know, you don't disclose that you're a red wine drinker on your application, and presumably there's a bunch of other things of that nature, you know, that you're maybe a messy bolognese eater. I don't know. Like there are lots of other things that could make a tenant unsuitable. I guess we are in this situation because there are landlords that think that pets are particularly damaging, despite the rules allowing landlords to be made whole. Do you think? I guess how much of this do you think is stigma and sort of a ingrained views versus actual risk to property? Is there some way that we can sort of chart a middle ground yeah.
Yeah,
Sorry, it's not much of a question.
I think
It's more of a
you're
reflection.
thinking just the way that we did in these consultations, and we did explore. Well, I certainly put my mind to it, and I'm sure other people did as well. And I'm not sure that there is, because as soon as you've got a process where an application form mentions that you've got pets, you've got this problem. And I don't know where I agree with you. I mean, education is part of the solution, because it's clear to me, and I'm probably a bit biased given that I'm an animal keeper and Vice President of Animal Care Australia and so on, and obviously the people who speak to us are people who love animals and so on. But I still think that it is true to say that the large majority of Australians love their pets and appreciate pets and have no issue with pets, and get that pets, look, like teenagers or toddlers or I think someone meant red wine drinkers, things happen, they happen in rentals, and occasionally they happen with pets too. But 99.99999% of them are things that are easily fixed, just the same as they are when somebody spills a glass of wine or something. So, but sadly, I'd love to come up with a way that's middle ground, so that landlords can sort of have a decent view of the tenant that they're proposing to take on. But unfortunately, I think the way that tenant applications are being looked at currently, that's not a realistic expectation to come up with that solution. It needs to be either we flip and we say everyone can keep pets unless the landlord goes through the process just to stop it, or you're just not allowed to know about it until the lease is signed.
Thank you. That was an excellent answer.
Thank you. And thank you all for giving your time to give evidence today. I note that owing to the extremely tight time frame of this inquiry and the hearing and the report deliberative, we have a very limited period for taking answers on notice and getting those answers. I can advise that the committee has actually resolved that the transcript corrections, any answers to questions on notice, clarifications to evidence, and any additional information that witnesses want to provide would happen within 24 hours on receipt of the transcript by the witnesses. And the Secretariat will be in contact with you in the coming days to provide that transcript and in relation to any questions taken on notice as well. Thank you again for your time.
Thank you. Thanks.
Thank you. We will now break for morning tea, and we'll be back at 11:15 a.m. Witnesses, thank you for making the time to give evidence today. Could I begin by asking each witness, starting from my left, to please state their name, position, title, and swear either an oath or an affirmation? Thank you.
Hi, Leo Pearson-Ross, CEO of the Tenants Union of New South Wales, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Eloise Parrott, Policy and Advocacy Manager at the Tenants Union of New South Wales. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And do you have a short opening statement that you'd like to give?
Yes, thank you. So thank you to the committee for the opportunity to present today. I acknowledge that we're on the lands of the Gadigal of the Eora Nation and recognise the present and historical disadvantage experienced by Aboriginal and Torres Strait Islander peoples, particularly in relation to finding a home. This bill represents crucial first steps in bringing fairness to the application process by protecting renters' information and providing frameworks for all industry participants. It builds on work started under former Minister Dominello on what information is genuinely needed to assess a person's ability to rent a home. We were pleased to be part of the industry reference group that ultimately helped inform the bill. While this inquiry focuses primarily on the PET provisions, our submission does also address other aspects of the bill and includes recommendations we believe would enhance it and ensure it meets its objectives. On 19th May 2025, the government commenced important changes to renting laws, including making it easier for renters to keep pets, a right the Tenants Union and renters had advocated for over many years. Once a property becomes a person's home, their private space, there should be a very high bar for interference with that space or the decisions adults make within it. Renters should be supported then to be responsible pet owners, just as owner-occupiers should be, making decisions necessary to care for an animal while respecting neighbours' peace and quiet. The solution to genuinely making renting with pets easier and addressing many of the concerns raised during the bill's progress through the Legislative Council and the Assembly requires reforming the current application process for a home. This process is functionally unregulated. It rests on opaque decision-making with no regulatory framework to support it. Ensuring that moving with a pet creates no disadvantage in finding a safe, affordable and appropriate home should be the aim of the New South Wales Government around making renting fairer with pets. No Australian jurisdiction has yet addressed this gap, and that shortfall creates the problems we're here today to rectify. Pending reform to that application process, there are still significant improvements we can make to the pet application process. The current system assumes a renter has no pet when moving into a new home or seeking permission, yet knows everything about the animal that they need to defend their application and feel confident going to the tribunal. This places applicants in a very difficult position. New South Wales should implement the standard pet application process now used in the majority of Australian jurisdictions, all but us and Queensland, which has been supported by tens of thousands of submissions across 2 significant New South Wales government consultation periods. This would prevent unreasonable refusals at the outset, requiring landlords to demonstrate the grounds for their refusal by seeking an order from NCAT, rather than placing that burden on renters, remains the key mechanism for removing many of the unintended effects of this bill on pet owners. We recommend the New South Wales Government examine the pet application process from advertising all the way through to decision making to ensure it is fit for purpose, though there are some clear elements like disclosures that can be advanced through this inquiry and in this bill. In particular, ensuring renters have sufficient information about the property, including information about any relevant factors about pets, will assist in avoiding time wastage and disputes around pets, as well as streamline the process for all renters when they're assessing whether a property is suitable for them as well. Thank you.
Thank you. And thank you, both of you, for your time today and for your fantastic submission as well. It's extremely useful. One of my biggest concerns, obviously, with this bill is the idea that in practice somebody could apply for a property, sign a lease, use that first 7 days, which is already very tight, to apply to have an animal, and that animal is refused, and then the legislation sort of stops on their protections right there. Even if they apply to NCAT, they still have to do something with this animal during that process. If they don't feel able to apply to NCAT, then they somehow have to try to either find a new property to live in with 24 hours or find somewhere else for that animal to live within 24 hours, which we're hearing quite a bit this morning, particularly from the RSPCA, that's just simply not practical. I'm interested in, what we can do, and I know you've sort of gone into your submission quite a bit, but just here again for the benefit of the committee, what are some of the key amendments that we need to see to the current bill before us that could provide some level of protection for renters with the current proposals?
So I think there's two elements: the information, the ability for people to know what property they're moving into will help with that process. So we already have in the bill some disclosures that in many ways a first step into regulating the advertisement itself, looking at digitally altered photos and the embedded networks disclosure. We can add to that the factors that the landlord knows about the property that are pet neutral. So if there's a bylaw that exists on the property, if there's special council rules, if the landlord lives on the premises, these are all facts that the landlord knows about before any pet is being considered. And if they can disclose that at the advertisement stage, they already know about it, then that means that those tenants who might be looking at the property can choose not to, but at the very least are on notice that there is a factor here that you are going to have to deal with in making your application, and you will need to have a really sort of strong argument to try and get around it. Tenant information, consumer information is generally a well-established good in these kind of markets. So it's looking for opportunities to share information that's already well known to the landlord is an easy and practical thing to do. The second part then is, well, once you have moved in, how do you address, like you say, this gap? You've moved in, at the moment the bill says 7 days. We had recommended 14 days as the more appropriate time just for making the application. But we also say that you should be protected from being in breach of the legislation while your pet decision is being considered, and that includes through the NCAT process. Switching the onus from the tenant to the landlord to apply to the tribunal would prevent this, because what we're seeing and what the current system encourages, or at least facilitates, is there is no check on the landlord's response to the initial application. And so it may be completely a fabricated agreement. It may not have any evidentiary basis, but there is no check on that until you get to the tribunal. So as an example, the number of pets, you can say under the regulation, less than 4 is generally a reasonable number. More than 4, the tenant might have to make a case to say how many. If you apply for a single cat and the landlord replies, there's going to be too many pets in this property, despite that only being 1 cat on the property, there is no oversight of that until the tenant makes the application to the tribunal. Now, that might seem simple, but tenants generally are intimidated by the tribunal to start with. There are many renters who may be nervous about engaging with that kind of dispute resolution because of their prior experience, because of their capacity, their capability, because they think that a person in a position of authority, the real estate agent, has told them that this is the case. Given that there's no oversight of it, it is then up to the tenant to pay $66, might have to correct the record on that, $66 to apply to the tribunal to just get that simple fact checked. And so this is a big barrier that gets in the way, whereas every other state and territory, except, as I said, Queensland, has another authority, whether it's the tribunal or in WA it's the commissioner, who checks the landlord's response to make sure that it is in line with the evidence and in line with the regulation. And that's a much more effective way of dealing with this problem. I think that those two methods in combination, information beforehand and a better decision making after, is the main way that we can deal with it once you're in. As I said, we do have generally a bigger problem that people are moving not able to disclose they have a pet, not able to have that conversation with landlords and agents because they know it'll put their application at the bottom of the pile. And so it's not a constructive conversation that they can have, which would be a much better pathway. But until we're willing to look at that, this is where the solutions we have. Eloise, is there anything I should add?
I think just a couple of things in terms of there being introduced into the bill a notice period once the tenant's been kind of exhausted all their avenues of disputing the landlord's refusal in tribunal, or even just accepting the landlord's refusal. There needs to be an adequate period of time for the tenant to look into other avenues for where they could rehome their pet. So having that kind of immediate effect is not good for the tenant, and it's not obviously good for the pet and the animal's welfare. So we've proposed that there be a 30-day time period to allow the tenant to find an appropriate place for their pet. And the other option that we've suggested is that the tenant be able to give a 30-day notice of termination to the landlord and end the tenancy without any penalty. So that will reduce, I guess, if they can't find an alternative option for their pet or they're not prepared to do that, then they have the option to exit that tenancy without having to pay that break lease fee and find a new property.
Thank you. You've also talked in your submission about data collection as well, and I spoke a little bit with the RSPCA about that this morning, and the general lack of reporting in this space. Can you talk about the changes that you'd like to see after, once this bill, potentially passes? What kind of reporting should we be really looking at to make sure that renters are being properly protected within this space?
So, as of 1st July 2025, the government is collecting information about every tenancy that ends by the landlord's action, so where a termination notice is served, collecting information about why that tenancy ended, and that builds on what was a voluntary survey previously. Now it's a mandatory collection, which was important because the voluntary version had a response rate from tenants of about 20%, which is quite respectable in survey methodology, but it was about 5 or 6% from landlords and agents. And there are a number of reasons for that, but we note that there was a significant difference. Now that it's mandatory, we haven't yet seen the first release of that data. We're very keen to see it, but we expect, and I think we understand that the response rate is much higher, 80+%, even higher than that, with follow-up. And so that is a good opportunity to gather from industry participants what happened during the tenancy. At the moment, it's the mandatory part is more strictly collecting the end of tenancy information, but there is an opportunity there to ask about other elements of the tenancy to find out what's happening, and tenants will also be able to respond at that voluntary level. We also need to see better data coming out of the tribunal, which is at the moment the decision-making, or the ultimate decision-making jurisdiction. There's a particular clause you have to apply under, so they are collecting that information, but the data reporting from the tribunal is doesn't currently include that. That would be both the applications made and the outcomes would be useful. There are also we know that the New South Wales government is monitoring listings quite thoroughly, particularly within the framework of the evictions and the exclusions on reletting. They are looking quite closely at realestate.com domain. I believe they have agreements with these bodies. Looking at the rate of pet application disclosures would be then quite simple to build into the already existing information frameworks that have already been set up. Mm-hmm. So if our recommendation around disclosures is taken up, that would be included, but even if it's not, we already have the ability to look at how many properties are disclosing no pets, or which would be unlawful, or putting voluntary information about their attitude towards pets in the advertisement stage.
Thank you. You've also got a suggestion that landlords and agents should be subject to penalties if they provide misleading information to tenants in relation to the animal application process. Can you talk a little bit about why that's an important deterrent and suggestion moving forward in that space?
So I think that it's necessary because we're dealing with an industry that while it has professional standards, compliance with those standards haven't historically been high. They are being lifted. There's an ongoing process through the Property and Strata Commissioner and its various names that is looking at increasing these standards. But we again and again hear of agents not following the rules, not having the understanding of the laws. So point one under the Property and Stock Agents Act, the regulation has a code of conduct there. The number one point is to maintain knowledge, and it names the Residential Tenancies Act as the first bit of law that you should know. And we continue to hear from agents who have not kept up with education. And as a body who's responsible and helps train tenant advocates and tenants, we understand it takes some time to read, but we're now many months in. We've trained our advocates. A body that retains $1 billion in earnings from landlords a year can maintain the professional standards. So we need to make sure that these standards are being lifted. We need to make sure that there are actual consequences for failing to maintain standards, penalties in the Act and also actively applied will lift that by sending the message that there is an active regulator who is paying attention, not merely some things in paper that you can ignore when it's inconvenient.
Yeah, thank you. And I suppose just kind of, and we've talked a little bit about some of the amendments that different organisations feel would need to pass within the current legislation that we're considering. And I know you've mentioned it a bit here in regards to making sure that the tenants can actually keep the animal at the property while they're going through that NCAP process, and potentially after that NCAP process, for a period of time to decide what they're going to do. I guess I just wanted to sort of get a bit of an understanding from your point of view, sort of what's the situation going to be if these amendments don't pass and the bill sort of passes as it is, what sort of situations is going to create for tenants?
So we know people who moving, as I said, who already have an animal are in a very difficult position because they've not been able to have these conversations before moving in. They're not necessarily being given the information or not being able to collect the information about whether the property is suitable. They don't have access to floor plans. They don't have access to necessarily accurate photos. They can't have these conversations. So you're in a really tough position, and if you don't have somewhere else for the animal to go, you need to bring it with you. This is why the grace period is important, that you can reduce the risk that a person abandons a pet because they feel unable to care for it, they feel unsafe, they don't have friends or family that might be able to care for it. So they need to bring it with them. And then if the grace period is too lax or the dispute resolution process is not completed, then they're facing this very difficult choice. Get rid of the animal who may have been part of the family for many years, who may have had a great history, whom they may have trained to be very well adapted to living in these homes. Give that animal up or move themselves. And moving is an expensive process, regardless of whether you pay the break fees or not. We estimated in 2022 that the average moving cost was about $4,500, not including the bond. Once you account for not just financial costs, but also time off work, childcare, all sorts of additional impacts, whether it's paid financially or borne by somebody else. And then you do have the risk of break fees, of having to give up a property that you've just moved into, that you've just paid to move, and then doing it all again, plus another month, essentially your whole bond in costs. And in the instance where that is because you have put in a reasonable application and been denied, but don't feel able or don't understand how to dispute that, that's a very unfair outcome. So, yeah, I'll leave it. Anything?
Thank you. I might see if the Honourable Aileen McDonald has any questions.
Thank you. Thank you for coming today. I think in your submission you said the application process is currently not fit for purpose. What do you think would be the key structural problems with the existing framework?
The application for a pet.
Yeah,
we've got two application processes. For the pet, the key structural challenge is that who bears the onus to go to the tribunal to go to an independent adjudicator. Like I said, in most states and territories it's the tribunal, in WA it's a commissioner. Either way, it is a person who can look at the facts and say, is this refusal reasonable? And if it is, then they'll say no, and that tenant then does have a problem to deal with, but at least it's been adjudicated, it's been checked by somebody with some authority. Putting it on the tenant, there's a number of reasons why that is difficult. Partly, you don't necessarily have all the information from the owner. They have to comply with the form, but not necessarily the substance, right, of the decision making. So as long as you get the form issued by the government back, that is sufficient to meet the requirement. And that means that you are going to the tribunal, a place that you might not feel comfortable with. You may not know whether your case is strong enough. You might read the information and feel like it looks right, but when you go to the tribunal, is it going to work? And so that puts a question in your mind. I mentioned there's the application fee, but there's also time off work. We see in the tribunal there is particularly in regional areas, we're seeing people with listings. They may be on the North Coast and the listing is made in Sydney and there's an assumption of video link, but that's not necessarily practical for people. So there is sometimes significant time around the hearing itself that you may not be in a position to take. You're in casual work, you don't want to put your employment at risk or something like that. So it's a big imposition without a really rigorous pathway to get there. And that's the barrier that means the pet applications can not have the outcome that the evidence would suggest should. And to the limited degree that we've seen cases go to the tribunal, certainly where advocates have been talking to people, we've seen a large number where the refusal is not supported by the evidence. And so it appears that it is too easy to just say no and wait for the tenant to apply if they want to, and otherwise it's make it the tenant's problem what they do with their home, with their animal.
So to address that, could there be, say, greater disclosure, like before a tenant applies, say in advertising, or maybe even, say when you do disclose that you've got a pet and then it may be refused, so if you had greater disclosure in advertising, would that reduce disputes, do you think, and unnecessary tenancy turnover, and what would that look like?
So yeah, we think, if a person is applying for an animal that is clearly not suitable for the property, I can give absurd examples, but then they kind of know that beforehand.
Yeah.
What you don't know at the point that you're looking at advertising is the facts about the building, the facts about the dwelling that are already in existence that the landlord knows and you don't. And so this information asymmetry creates a problem for you, and it is something that is fixable. So there's a number of factors a landlord can refuse a pet on. Most of them have to do with the animal itself, but they're also mostly relatively testable by the tenant. They can know what the answer is. So that, the number of animals in a property, as an example, how many you're asking for. But what you don't know is where what bylaws exist. The disclosure of bylaws under strata doesn't happen until after you move in, or at least after it's too late to back out. And so that's something that could go on the advertisement. There's a lot of space on online advertisements to put in simple lines saying that the landlord says this or that about the property. We don't need an essay. It can be a relatively simple disclosure, but it puts the tenant on notice, and then they can make the decision about whether it's worth challenging that. And we would suggest most of the time they wouldn't, because they've been given that information up front. They'll go move on to another property. And I just say, I think to a degree there is resistance sometimes to these disclosures because the owner is worried that it would, or the industry is worried that it would reduce the attractiveness of that property to say something about it that might not make it appear in the most attractive light to the widest number of applicants. But that is healthy. That's a market functioning well, where consumers can make informed decisions about the thing that they are trying to decide. So hiding information is not the answer there. But that appears to be the root of a lot of the resistance. Is there's a worry that by being honest and upfront about your property, that you might not achieve the same rent that you would otherwise.
Yeah, okay. And so say if at the moment, say the bill prohibits that you have a pet, but I don't think it has reduced discrimination against renters with pets. What's your view on that?
Yeah, so this is the application for the home. That when you are applying for a property, as I say, it is functionally unregulated. Technically, there are discrimination laws. You can't be refused the accommodation on the basis of your age and gender and so on. But the decision making, the process of assessing applications is designed to maximise competition. So an agent or a landlord will collect all of the people who are interested in a property and then assess all of them in comparison to each other. And you don't get feedback on why you didn't receive the property. Only the person who was successful will be told you were successful. And so what that means is any number of factors may go into that decision making. They're not enunciated, you don't hear about it, and one of those we know, and because people say it publicly, they would put pet applications at the bottom of the pile. They just won't consider it if you talk about it. And so there's the possibility of both lawful and unlawful discrimination in that process. It's enabled by the particular approach to maximising competition. And that also puts a lot of pressure onto the property manager, who's being asked to assess many dozens, maybe hundreds more applications than they actually need to. If they were assessing each person on their own merits and checking, can you afford the rent, yes or no, then they might only need to assess one application, find the tenant and move on. But because the industry is attempting to maximise the gain through collecting as many people as possible, including by encouraging people to come to inspections, to put in applications even if they know they're not going to get the place, because it puts pressure on everybody else. So that's the really fundamental change that needs to happen there. Restricting questions about pets is an important part of that, of reforming the application process, just as the bill restricts information about a number of other things that are just not actually necessary to assess whether a person is appropriate to move into the property. But what the bill didn't get to was examining the decision-making process that was happening behind that. So it restricts the information in, but it doesn't look into the guts of the decision-making process.
And you've already said before about, if you have to go, so if you say you have the refusal, that 7-day period, do you think is workable? And you've already sort of alluded to some problems with that. Are there others that...
Look, we had said 14 days, so there's very basic problems with the 7. One is that you move in, if you are serving that notice by post, Australia Post's standard delivery is 7 days, and so you have to apply on the day you move in, on that afternoon, in order to guarantee delivery. It's just a very tight turnaround. You may not have had the time to put your thoughts together. So on that basis alone, we were saying 14 is at least the starting point. But this is a conversation. There may be communication back and forth between the tenant and the agent discussing the animal, and that should be allowed to run. And then it should be able to go to the tribunal without the tenant having the possibility of a breach notice hanging over their head, which is a technical possibility at the moment.
And then just say they've been refused the pet, they've taken that decision, so should they be allowed to terminate the lease without penalty if consent is not provided?
Yes, and we went a little bit further as well in saying that if we have the disclosure in the advertisement, if the refusal is on one of those factors and that hadn't been disclosed, then the tenant should actually have their moving costs paid for, because they've been essentially misled into moving a property, putting an application without the information. But certainly, a person who has just moved, has in good faith applied, there's no suggestion that they are taking the mickey, then there's not really a good justification for them then having to shoulder a significant amount of cost again, because of the process not being adequate for a genuine decision making.
And I have just one final question. What would be, if you could only have a single amendment to this committee, what would you recommend to, and in a way to prevent unintended consequences?
We find it hard to be that.
Yeah,
Look, I think that as we flagged, the application process for the home is actually the root problem here. Within the terms of the bill and close to the intentions, moving that onus from landlord to tenant is the most realistic and straightforward thing that could be implemented immediately.
Thank you.
Does the government have any questions?
No, thank you, Chair. We're fine.
Thank you. Ms. Boyd, did you have any questions?
Thank you, Chair. I do. Good morning to our witnesses. I just wanted to ask about the consultation process. So I understand there was quite detailed consultation on the bill before it was put forward, and that the main sort of change that surprised everybody was this reversing of the onus of who needed to take a dispute to NCAT. What was your understanding of those consultations, and at what point did you discover that model that we thought was going to be in there with the landlord having that obligation had not made its way into the bill?
So there's probably some steps to clarify. So thinking about the pets reform generally, we had in the previous government had opened up an initial consultation on pets specifically, and that had a number, more than 10,000, I can't recall exactly, responses that made it very clear a strong desire from renters and mixed feelings from landlords and agents, but not it was not a mirror image. It was strong feelings from tenants and mixed decision making from landlords and agents. government, then that was the summer before an election, so it didn't translate into a bill then. The current government had making renting with pets as part of their election, making renting with pets easier as part of their election platform. And the pets reform was part of the consultation into, I believe the amendment bill was improving rental laws. I may have got that wrong, but it passed in October 2024 and came into effect 19th May 2025. In that process, there was another consultation, again, very strong support, and the New South Wales government's report on the consultation reported 93% of renters supported a approach to the decision making, where the landlord would have to apply to the tribunal. 93% supported the same model as had been at that point put in place in Victoria, ACT, and subsequently has been everywhere except Queensland. The report didn't disclose the particulars of what landlords and agents supported or not, but again, a mixed feeling. We were part of the consultations around the development of that bill, and including the pets, and we understood as that was going ahead that the general trajectory was that we were moving towards the Vic ACT model, maybe with some differences in specifics, but generally speaking, we were moving in that direction. We found out that that New South Wales had determined to follow the Queensland model following a media announcement from the Premier, the Commissioner, and others. In the lead up to that bill. So I can't remember the date, but earlier in 2025. And that set a change in process, so essentially the department had to go back and rejig all of the settings that they'd been talking to us about in order to make the Act and in the background, knowledge of what the regulations would look like, fit what had been announced by the Premier at that media event. And so we heard of this, some months before the bill was passed in Parliament, and we made a number of submissions saying this was the wrong path. We should be going for the rest of the country. And the trajectory there rather than Queensland. We had the advantage of knowing what it looked like in Queensland, where many people still find it very difficult, and we knew that going into it that it was very difficult to apply. There had been some successful tribunal applications, but very few tribunal applications were being made to address it. So that then passed Parliament in, as I said, across August, October, I believe the October 2025 was when it passed both houses. And then we had the regulation process before commencement in May. This bill before us follows on from that and includes additional changes around the pet process that the department, the government had identified as necessary through that. We were part of the industry reference group, mainly focused on protection of personal information rather than on those particular pets. So we were probably aware of some of these before the bill presented, but there wasn't the same level of consultation. There was several meetings of a wide range of stakeholders talking about the personal information part, which is the substance of the bill. So I suppose there's two different legislation parts there.
That's incredibly useful. Thank you very much for setting that out.
Thank you. Is that you don't have any further questions, Ms. Boyd?
No, thank you.
Thank you. I might just jump back. In the last group that we had, there was an important issue that was raised in that the current legislation before us, it really sort of sets out how someone first moving into a property could apply to have an animal. but it sort of ignores situations where somebody's already under a lease and they may, for example, the example that was given was, there's a deceased relative, that animal goes to this person who's renting, so that animal doesn't end up in a pound, for example, and how they then enter this process as well of trying to actually get approval for that animal. I just wondered if you had any suggestions on amendments that could help tenants in those situations, and also with consideration, I suppose, of how do we make sure that also doesn't sort of set up a situation where somebody gets an animal, has that animal, has 7 days to apply to have that animal, gets a no, and then potentially we see more surrenders, for example, through an accidental sort of loophole there.
So I think we might characterise that slightly differently. I think that the legislation assumes you're already in the property. The whole framework, so not just this bill, but including the already existing rules, already assumes you're in the property. And so the person who has moved in a week ago or moved in 9 months ago follows the same process, and has the same basic barrier that the landlord's refusal may or may not be reasonable, backed up by evidence. So long as it follows the form, it puts the onus on the tenant to apply to the tribunal, and that's the big problem. What is different is when you are at the very beginning of the tenancy, you're also a long way away from, or relatively a long way away from, the end of the fixed term contract. And so, 12 months is basically standard in New South Wales. We would like to see longer tenure, not necessarily longer contracts that bind tenants in, just for the record. But you're approximately 12 months away. And so if the landlord doesn't like that you asked, regardless of the outcome, and let's assume that you're successful, the tool of a retaliatory notice has been reduced with the introduction of reasonable grounds, but not removed. And there was a bit of attention a few weeks ago. A renter called Annalise asked to care for a pet from a friend of hers for 6 months, so she wasn't even asking for it to be permanently in the home. She put in the application in the morning, and in the afternoon she received a notice of termination where the owner asserted they were moving in to the property. So it was given 90 days notice. That, and her suspicions were, and it's impossible to check in the moment, but her suspicions were that was a retaliatory notice. She hadn't heard of these discussions, and that kind of worry about whether the lease will be renewed hasn't yet been addressed. The reasonable grounds reform helps, but is not yet settled. People don't yet have the confidence that the notices will be genuine. There's a number of factors in that we can go into, but the general confidence in the system hasn't been bedded down yet, and so people are worried about that consequence. I suppose the other that they would be worried about is rent increases, which are again largely unregulated in New South Wales. There is a system around excessive rent increases, but very difficult to pursue with confidence. So people are worried about that. They're worried about the retaliation, the consequences of asking for a pet, because they're conscious that the owner may react poorly, and will use the tools that are available to them to decline the pet with or without the application process. So there are a number of changes we can make there. Again, the onus of going to the tribunal helps, but doesn't resolve that worry in the first place. I think making sure that those notices are always genuine, always backed up with evidence, and the regulator is active and visible in acting to make sure that those things are happening is what's really necessary there.
Thank you. And just one last question, I suppose. Putting aside and I know it's hard to put it aside because it's all tied together, but putting aside the sort of previous bill around who the onus was on in regards to going to the tribunal, if the bulk of the amendments that you have proposed pass in this bill, do you think that deals with, the biggest concerns that you have for tenants in regards to the changes within this bill going forward?
Yes, I think our recommendations within what the bill is trying to achieve would allay a lot of concerns about how it will play out in practice. The part that is the two parts not addressed, the application process for the home is obviously hard to untie, but we also understand that is a big piece of work to untie that process, and so that our recommendation was that it should be examined rather than trying to lay out a whole system. The changing of the onus, again, we asked for it to be re-examined rather than proposing a specific legislative change, although it could be done through this bill. Those two are the unresolved parts. I think that the rest would go a long way, particularly that disclosure, that extra information that people have before moving in.
Great. Thank you so much, and thank you so much for your time today. I note that owing to the extremely tight time frame between the hearing and the report deliberative, there's a very limited window to any questions taken on notice. But I can advise that the committee has resolved that transcript corrections, answers to questions on notice, or any clarifications to evidence or any further information that you want to provide to the committee is to be provided within 24 hours on receipt of the transcript to the witnesses from the Secretariat. So they'll be in contact with you over the coming days in relation to any of those questions on notice and to provide you with the transcript for today's hearing. And thank you again for your time.
Great. Thank you.
Thank you. Thank you. I now welcome our next witnesses. Could I ask each witness, starting from my left, to please state their name, position, title, and swear either an oath or an affirmation?
Jason Partridge. I'm representing the real estate REI New South Wales. I can state the affirmation. I'm solely, sincerely, and truly declare that affirm that the evidence that I shall now about to be given, and I shall be the truth, the whole truth, and nothing but the truth. Thank you.
Thank you.
James Rubin. I'm the current Vice President of the Property Owners Association of New South Wales. The affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
I'm John Gilmovich, President of the Property Owners Association of New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Does the Real Estate Institute of New South Wales have an opening statement?
We do.
Thank you.
Good afternoon, Chair and members of the committee. My name is Jason Partridge, and today I represent the Real Estate Institute of New South Wales, the property managers working in the industry, and our landlords whose properties we manage. Firstly, I'd like to acknowledge that the industry supports the objective of improving privacy protections for tenants. Protecting private personal information is important, and we recognise that a trust and transparency is essential for a fair rental system. However, we do have concerns on some aspects of the proposed bill and that don't reflect the realities of tenancy management. Property managers have a dual responsibility. We must protect the financial assets of the landlords who own the property, but also ensure that tenants aren't placed in residential agreements they cannot reasonably afford. To achieve that balance, it is essential for us to be able to assess applicants thoroughly, verifying rental history, financial position, and identity. Without this ability to verify this information, there is a real risk that tenants may be put into residential leases that put them under financial stress, while landlords are exposed to significant financial risk if tenancies fail. Importantly, we do not see this as a tenants on one side and the landlord and the property manager on the other side. Our industry reflects the broader rental community. Many property managers themselves are renters. The fastest growing property investment type is what we call rentvestors. These are people who rent where they live but own an investment property that they provide rental housing for others. Additionally, the vast majority of property investors have family members, loved ones, and that are tenants themselves. The truth is, this is one community working together to meet everybody's housing needs, with the overwhelming majority of participants acting responsibly. We agree that tenant privacy can be improved and that better systems for managing personal information should be developed. Our industry supports these important implementations in these areas. However, these implementations can't be at the expense of landlords being able to protect their asset and property managers have the ability to represent and responsibly assess tenancies and manage tenancies. For example, the provisions relating to identity verification may require further clarification to ensure agents are still able to verify applicants' financial capacity and retain appropriate documentation where necessary for potential further tribunal or court proceedings. Likewise, the provisions allowing pets to remain in property while the owner is still assessing the request could create uncertainty, whereas if the eventual pet is declined for legitimate reasons. Finally, I'd like to consider the broader housing situation. At a time where rental supply already under significant pressure, regulatory variations should avoid unnecessarily discouraging property investment. We have seen in other jurisdictions the rapid change of regulatory change has led to a significant reduction in rental housing supply. Ultimately, our goal is not to oppose reform. The industry supports stronger protections for tenants and improved privacy standards. What we are asking for is continued consultation to ensure these changes work effectively in real life practice, allowing property managers to responsibly assess applications while managing confidence for property investors who, without their properties, we simply don't have a rental market. Thank you for the opportunity to contribute today.
Thank you. Is there a submission from an opening statement from the Property Owners Association?
Yes, good afternoon, Chair and Committee. We were given a very short period of time to make a submission. This feels like it's being rushed through once again. Property Owners Association has been at the forefront of a key stakeholder in New South Wales for the last, we've been around since 1951, but obviously not me and James, but the last 25 years we've been heavily involved in tenancy reform. We feel this particular bill is merely a sugar hit and not really addressing tenancy issues at hand or looking at a future for housing that many years ago predecessor at the Fair Trading said that we want to go into the future and leave the past behind. This bill has certain clauses and ideas and policies in it that we feel are going back to the 1980s and not really addressing modern day living. Furthermore, the immense pressure on housing, immense pressure on cost of living. If these sort of bills go through with tinkering at clauses, it will add further pressure on the housing market. And from my understanding, the Minister's speech said that the bill is trying to establish a fair renting system. We are still yet to understand what is unfair about the current renting system. And there's only one quantifiable thing at play, and that's the actual cost of renting a property. All these layers, continuous added layers of legislation and compliance and property upgrade will no doubt lead to higher costs in running a property, owning a property, and of course those costs eventually being passed on to tenants. So we need to have a long, hard look at this particular bill. There's a lot of issues with it that obviously we'll discuss in what we feel is not the future of a fair renting system, although we're all for a fair and equitable and reasonable system between landlords and tenants and all key stakeholders in property. However, over the last 15 years of our involvement in making submissions to government, it certainly doesn't feel like we're going in the right direction, and certainly the evidence is there that the housing crisis will worsen.
Thank you. I just want to start with a couple of questions myself before I throw to the committee. A number of submissions that we've received to this inquiry have sort of talked about as well that they want landlords to actually disclose in the ad if the property specifically is not suitable for animals under the previous legislation that passed. And some of the explanations for that is so that tenants don't necessarily apply for those properties when they've got animals, and it also sort of overcomes this concern that we've been discussing this morning, where somebody moves into a property, potentially applies to have an animal, is refused for a genuine reason, and then obviously that puts both the landlord and the tenant in a very difficult situation because the animal is currently in the property, and you could end up seeing new tenants breaking leases almost immediately. I wanted to get your thoughts on whether there should be some sort of very basic information about whether there's a law or a bylaw preventing somebody from having an animal and whether that should or shouldn't be in the advertisement for the property. I might throw to you guys first and then...
Our position about pets and animals, we're not against it. We're pro-choice of property owners and owners corporations, that obviously with strata living, to make decisions with all facts and information at hand, whether a particular animal is suitable to go into a premises. At the same time, there are a vast many reasons as to why a landlord chooses not to have a pet in their property. It could be even their own home that they live in, and they may have allergies and other medical issues surrounding the keeping of animals. As far as your question around suitability, well, obviously the property managers and the landlords really don't know anything about the animal except for what they see in an application form.
Sorry, just to clarify my question, sorry. Yeah. But, we've got like two pieces of legislation. We've got the one that's in front of us now, and then in the previous legislation that's somewhat linked to this legislation, there was a legislated list of reasons that a landlord can refuse to have an animal. And so, some of those reasons were very black and white. The one example that you just gave, that the landlord resides at the property, for example. And so I guess I wanted to get an understanding of whether you think, I mean, it wouldn't necessarily need to say on the ad, the landlord resides at the property, but perhaps on the ad it would say that there is a specific law or bylaw that prevents animals from being in this property, and that's disclosed in the advertisement section. Not necessarily for every single aspect, but for those ones that are really black and white, so that tenants are aware of that before they apply and move in with an animal.
Yeah, sure.
Look, I think the short answer is there's obviously a need to regulate this. The reality is most people that have pets are fine and they follow the rules and the pets are not a problem. The issue that we've got here is obviously that the situation which you described correctly, which is you don't want someone to go into a property, then apply for a pet and then find out they can't have it. They're several weeks into their tenancy and then it's a headache for everyone involved, including the tenant and the owner and the agent. I think advertising, I suppose while we're cognizant that we don't want to create a burden on managing agents and we don't want to create a burden on owners of properties that they need to or they're required to advertise additional things in circumstances where a property is clearly unsuitable for a pet. I think it makes sense to include that in the ad, is the short answer, is that, this property has 2 bedrooms and da-da-da-da, and it's not suitable for a pet. And, as long as it's clear that that's there, I mean, that would obviously alleviate some of those situations. It's taken on it, each application would be taken on its face value, on the facts at the time, and so there will still be circumstances where the situation that you described arises. But I think, if there's, for example, an allergy reason and the landlord resides in the property and it's just not going to, no application is going to be approved and there's a legitimate reason for that, I think indicating that at application stage is probably a sensible idea to prevent the potential of the later headache that might arise.
So on one hand, you have this situation. On the other hand, as the property owners, we also don't want to close off the marketplace as well. Because, I would say a good 50 or 60% maybe are pro-pets, maybe more. But at the same time, we don't want to close the market by putting a disclosure like that on the ad, preventing 20%, 30% of the renters out there to not apply or look at the property as well. So you've got to find balance. But practically, you would want some sort of a pre-application process to approve before moving into the premises, not the other way around.
I guess the concern that we've heard this morning is that if the application is made or a declaration is made before moving in, we were given examples where people just couldn't enter the property market, and this was particularly problematic for people leaving violent situations. For example, we've got research 70% of people stay in violent situations because they can't find a property with animals that will accept their applications once they actually indicate that they've got an animal, and many of those people end up applying and not declaring that they've got an animal just to be able to enter the property market. How do we fix that situation then? Like if it's sort of, if you're saying we've got to apply or it's got to be kind of upfront, and that kind of blocks a whole lot of people out of the property market and they can't find a rental in an emergency situation, and they end up not declaring something and then landlords don't have this information to hand, I mean, how do we then balance that?
Well, declaring and not declaring are two different things. I believe the current legislation pretty much allows for pets to move into a property within reason and not taking consideration the 7 reasons why they can be declined. So maybe if you're honing in on a domestic violence situation, that whether it's right or wrong to categorise those classes of tenants, maybe remove an obstacle there. But at the same time, I believe that the current legislation pretty much allows a tenant to keep an animal within the current rules.
Can I just add to that? I think quintessentially the current legislation without the amendment does require, like, there's an onus on a property owner to accept an application with a pet in most circumstances, except for there's prescribed reasons for which you can decline a pet. And I think I would be encouraging applicants to rental properties to be honest and truthful in their applications, even in circumstances where that might not be comfortable. Because part of the problem is there is an existing obligation. Like if an application is made and it says, well, I've got a pet and I'd like to have my pet there, that's not a reason for an application to be declined, except for in those circumstances, and that's already the case. And I think if there's a problem where people are not putting that on their application, and then that is leading to a situation where they get down the track and they're now in occupation of a property where they've falsely, they've misrepresented information on their application, and now they're in a situation where there's a legitimate reason that they can't be there. Like, that situation has arisen because of the misinformation, and obviously I can understand there's situations where applicants, and as you suggested, there's no doubt about it, there's situations where applicants are not inclined to represent because they have concerns that, it'll make it more challenging to secure a property and all of these things. But I think the forward advertising is not necessarily going to resolve that problem if the problem is that people are not declaring it in the first place.
Yeah, and so we heard this morning, we heard both from the Animal Welfare League and the RSPCA that the new laws haven't really had any effect, similar to Queensland, because of the way that the laws were designed to put the onus on the tenants. And so they're finding the same number of animals being surrendered into pounds and into rescue centres for the reason that they can't enter the rental market and find a suitable rental with their animals. So the information we're getting today is that the current situation actually hasn't changed for many renters. And I guess, what we're sort of now tackling with is, well, then how do we make it easier for these people to be able to actually enter the rental market if they have an animal with them, particularly for these vulnerable groups, and make sure that they're able to actually access rentals, because we also had a lot of evidence this morning from different organisations that, if there's a big market at the moment for rental properties, and if as soon as somebody ticks that they've got an animal, they say that their application is essentially automatically ignored, and it's not until they take that out of their application that they can actually enter the rental market and find a rental property. And so, it was sort of like, well, how do we deal with this situation? Simply saying, just be honest on your application. If they're going to continue to be refused and they're trying to leave a violent situation, obviously that's not a realistic situation for real life for many people. So I'm trying to, get some thoughts about how we actually deal with that.
Jason, can I jump in? Is it
Yeah.
Thanks.
From an agent's
I'm on a ground property manager. I deal with this every day, and I can assure you that there is no discrimination against tenants for having pets. It's like 70% of our owners are pet friendly. And when we have applications, the far bigger reason why people get rejected for applications is affordability purposes. We have a responsibility not to put people in a property that they can't afford. Now, it's easy to go back to a tenant advisory group or whatnot and say the reason I got rejected was because I have a pet. But there's no evidence to say that that is the case at all. They even admitted today when they were talking that there's no evidence, there's no statistics to say that the feedback is based on the fact that they've got
I think they said that there was no data. There was no data being recorded to actually show that that was the reason for
they also stated
refusal.
that there's no reason given when an applicant is rejected.
Yeah,
so how can they assume?
They're saying that there was no data. There was just anecdotal information from people that once they took that off, they were able to enter the rental market.
From a property manager's point of view, I'd far rather approve a person with a pet already on the application than to put somebody in there without a pet and knowing that they can then turn around and get any kind of pet. We can control the situation a lot better by being upfront and honest, and I don't believe it's the right move to not have the pet apply on the application. There's discrimination measures already in place. The old Act has very specific reasons why a pet can be refused or not refused. And as far as I understand, the statistics I know is that every single case that's gone to the tribunal has been overruled in the tenant's favour when it comes to pet discrimination or a pet applying for be in the property. So I don't think the mechanism's broken. I just don't think that you've got enough time to base it off this is working or not. When you're getting to a surrendering of pets, and I totally understand, I'm a pet lover myself, but we might have to look at the simple fact that the amount of surrendering hasn't changed, and it may very well not change when you bring these new measures in at all. But domestic violence is a perfect example when you're saying that it's not fair for somebody who can't get a rental property going through domestic violence. Now, there's already measures in place where we are not able to discriminate against domestic violence, and nor should we, but we're not even supposed to know that they're a domestic violence person. So if you're going to change the legislation to identify that they get a different ruling than others, then you're just outing people that are going through domestic violence.
Yeah, I don't think that's maintainable.
And on top of that, just explain this to me. If somebody moves in for domestic violence purposes and then admits that they've got a pet, and then they come along and do the 7-day turnaround, and the ruling is that the pet isn't allowed to go there, how much trauma does that person go through who's already suffered domestic violence, moving to a property and now have to relocate and find an alternative property?
But that's the problem I'm highlighting.
Yeah.
Because the other alternative then, if we don't make it so that it's easier for them to find a rental, is to leave them in the violent situation where they could be killed.
Well, nobody wants that. No,
But
absolutely.
that's what I'm saying. And so you're sort of like,
Being
at the
upfront,
moment,
though,
these are the sort of the two options: leave them in the violent situation where they'll get killed, or make it easier for them to enter the rental market with the animals so they can leave a violent situation. But yes, now we've got this new problem where they could get thrown out in 7 days.
Exactly.
And so that's what we're trying to fix
I
here.
think everything we're talking about and what I've witnessed this morning is trying to have a workaround for something that might not be the best idea to start with, and that is to not disclose that there's pets on the application. Now, if you're a parent and you've got children, you wouldn't not disclose you've got children on the application. Pet owners see a pet as a family member. I don't understand why admitting that until after they move into the property is a good idea. I really don't. All it's going to continue to cause conflict between the landlord, the agent, and the tenant.
But you're going back to saying leave them in the violent situation where they might be
No,
killed,
absolutely not.
which is
That's not
the
what I'm
whole
saying at all.
problem that we're sort of tackling with right now.
I'm saying let property managers help them find properties that will accept the pet without question, and therefore there's no event where we ask to move out of the property in 7 days from when they apply for the pet.
Sorry, Ms Boyd's had a hand up for a while. I might throw to her.
Thank you, and good afternoon to our witnesses. Just listening to the evidence just then from you, Mr. Partridge, it does seem a little bit at odds with itself in that, on the one hand, you're saying that there is no discrimination against pets. It's not really a big issue. There's a significant portion of landlords that are quite happy to have tenants with pets. But on the other hand, anything that actually recognises that acceptance in law is problematic if it results in a tenant being able to just bring their pet with them without any sort of consequences. I'm trying to understand.
Sure.
I think one of the really compelling arguments that was put forward by our first panel of witnesses was around this idea of you don't ask people if they're red wine drinkers, you don't ask people if they're messy bolognese eaters and are going to get tomato sauce all over the walls. Why is it that there is such a stigma around pets, particularly when you have the same rights as a landlord for any damage caused by pets as you would by red wine or something else?
Yeah, I don't really understand you. Can you just rephrase the question? Sorry, you were saying that
You're comparing red wine with
an animal,
a live animal,
yeah,
going into a property that could potentially damage the property, bite someone in the common area, or leave an absolute mess, as we know some pets have done and caused. So I think the comparison is ludicrous to raise that sort of thing. The issue is what I'm finding at the moment is that you're proposing just a blanket rule of a property owner having no choice, zero choice, of deciding whether they allow a pet or not, is what I'm hearing today. As a property owner, why wouldn't I be able to have a choice whether I allow a pet in or not? Let's say due to health reasons.
Yeah, so there are two things.
It's my property, I live in it, I've moved out of it, I've rented it out. I do not want a pet in there because I've got severe allergies or health issues. I'm planning to come back to that house one day.
Right, that seems like quite an extreme circumstance, though, doesn't it?
It's not extreme at all.
It's not. Perhaps. Right, okay. Can I ask you, do you have family pets?
Yes.
Right. Do you have a problem with your pets wrecking your house and biting people? Is this something that, or is this just other people's pets that are problematic?
Well, you can't just categorise just one pet. There are incidents that happen every day. Yes, they do bite. Yes, they do bite floorboards, scratch, put holes in walls, pee all over the place, pee on carpet, bite the neighbour.
But is that what your pets do? Why are tenants' pets more unruly than a landlord's pets?
It's not tenants or my pets, it's pets full stop. It's a wild animal going into a property.
It's not a wild animal, it's a domesticated animal. But I'm trying to understand. So on the one hand, your colleague there was saying that there's no problem, people are not going to get discriminated against if they say that they have a pet. But on the other hand, we hear you, Mr. Gilmovich, saying that actually there is a presumption that pets are problematic and are somehow going to run rampant around your property and cause a problem. I mean, which is it? Do we need to protect tenants from landlords who are going to discriminate against them, or don't we?
We don't need any protections. What we need is pro-choice.
For the tenant or just for the landlord?
For the landlord. Because at the moment they don't have a choice. Because the new legislation that got started and enacted pretty much allows a tenant to move a pet in on application. What I'm finding, I'm close to the property management industry as well. What I'm finding and what I've found in the last 2 years doesn't match up to the facts that were presented by the last witnesses. We have seen a surge of pets going into property, including vast majority in the strata. And what's happening as well is applications right at the start, pre-tenancy, pets are not being disclaimed at all. What's happening is once a tenant moves into the property, 2 to 3 weeks later, they put a pet application in.
Yes. Can I just ask you, sorry, coming back to the questions. So what I would put to you, I find your view quite extreme. And I think when we look at all of the people who are consulted on these laws over the last few years, it is only yourselves that really is putting in, sort of arguing strongly for this argument that there should be this assumption that tenants can't have pets without permission, and presumably also that a tenant is the one that needs to take the matter to NCAT. Given that you're the only ones that I've heard saying that, was it yourselves who lobbied the Premier to overturn the state of the bill when it was going to put that onus on landlords to take the matter to NCAT?
Why is this question relevant to this hearing?
It's very relevant, isn't it? Is there a reason you don't want to answer?
Can you explain that further, why it's relevant?
It's relevant because the bill that was then presented to the Parliament is not representative of the input and the consultation process. So people are very concerned.
Yes, but that's on the tenant side of things. But we represent the landlords and property managers.
So being the representatives of the landlords that you are and trying to do that job as effectively as possible, did you lobby the Premier?
We put a submission in saying that we are open to having pets, no issues at all. We put a proposal of a rental pet bond to assist tenants moving into properties with pets. But at the same time, we also put a proposal in that we would like to have a choice.
Yes,
as
but
the property owner.
Did you speak with the Premier when you became aware that the Cabinet had actually approved a bill that didn't have that in it?
Do you remember speaking to Premier? I don't.
I'd like to speak to the Premier. I've got a few things to say, but I haven't had that pleasure yet.
Did somebody lobby the Premier on your behalf? Perhaps Mr. Yemmer?
No.
No lobbyists on your behalf?
Point of order, Chair.
Sorry, Ms. Boyd, there's been a point of order.
This has been a somewhat consistent theme asking, and I've been reluctant to date, but the points being raised by Ms Boyd relate to the 2024 bill, which was already debated and passed. This particular one is related to the bill we're considering, so it would be helpful if we stuck to that frame.
Just to the point of order, Chair, we've had a number of recommendations in the submissions in relation to this that are clearly saying that NCAT presumption needs to go back to what it was in the bill as it was drafted prior to it being introduced in 2024. We've had submissions asking this inquiry to actually ask these questions, and so that is what I'm doing.
Thank you. And look, I also take note the fact that the Minister introducing these bills has very clearly indicated that the bills are linked, and that he was doing it in tranches. And so given the outcomes of the 2024 bill obviously impact the outcomes of this bill and the purposes around this bill, I will allow the questions.
Thank you. So just to close off on that then, can I just confirm whether any of you, either directly or indirectly through any sort of lobbyist or other entity, lobbied or advocated strongly to the Premier just prior to that press conference for this to be changed and for the bill to be presented differently?
No, we didn't. And secondly, we weren't even consulted on this bill, and we've never even met the Premier.
Sorry, not this bill.
If you could ask the Premier to consult with us in future for property-related bills, that would be actually very appreciated.
Okay,
you'll be able to find our policy positions, which we can share with you on all sorts of property-related things.
So your evidence is that the Premier just unilaterally decided...
I have no idea why the Premier did what he did.
...to change the bill.
No idea.
The Premier does as what he wants to do, but we were not consulted on this particular bill.
No, the 2024 bill, are we talking about the same thing? Let's just be very clear that we're talking about the same thing. I'm talking about the bill that was presented in September 2024. There was a press conference, and just before that, the Premier flipped and decided suddenly that the landlords would not be required to be the ones taking these matters to NCAT, and instead we'd followed the Queensland model. Did you lobby him before that, either directly or indirectly, so that he would make that change?
No, we didn't.
Thank you. I am going to have to go to Ms. Aileen McDonald. If there's more time, I'll come back to you. Thank you.
Thank you, gentlemen. I might start with you, Mr. John Gilmovich. Is that what you said? Yep. So your submission suggests that the bill introduces substantial penalties and administrative burdens for landlords. Yes. Could you outline the most significant compliance challenges?
There are many on this front. From what we read in the bill, protection of personal information, the bill presents an argument to eradicate the use of third-party application apps, and eradicate the ability to vet tenants properly to see if they're financially fit or credibility fit to move into a property. The property management industry and private landlords rely heavily on technology to help and assist the burden of day-to-day running of property portfolios. Those property apps probably eliminate about 40 to 50% of their workloads with a streamlined process and a systemised way to keep records and be able to vet tenants correctly and be able to present to property owners a list of tenants that qualify or could potentially qualify as the best fit for tenants. Removing such things would add immense pressure on time, which means that more resources have to be added, especially real estate businesses are generally small businesses or private landlords manage their own properties. And you would need extra staff, extra costs, extra time to be able to process what are dozens and dozens of applications per property on a Monday morning after a Saturday open hours weekend.
Okay. And
as well as potentially causing serious mistakes in choices of tenants.
Because you have to do them via...
Because you have to manually do everything. So what I said earlier in my opening speech is we're going back to the 1980s way of doing rental management.
Okay.
Could I just add to that? Is that okay? The real issue here is the amount of applicants that apply. Restricting these external sources to make it easy and convenient for tenants to apply, number one. Number two is it would go back to first in, best dressed. So therefore, not everybody would get a fair opportunity to apply for the property, and that just doesn't seem to be fair to the tenants if they see it 2 days after somebody else or apply 2 days after somebody else, because of the amount of manual work, as you're suggesting, would mean that some of those applicants wouldn't even get processed. That doesn't seem fair.
So you would argue that they should still be able to have these third-party apps or technology to be able to process or vet?
Yes, because those apps help and speed up the process of actual approvals. That's number one. Number two, they lower the burden and the sheer time it takes to actually process 10 to 12 applications per property. And in an average real estate business, there could be 5 to 10 open homes over the weekend. So we are potentially talking about 100 applications to be processed. And that's on top of a general property manager trying to manage a portfolio of 150 to 200 properties.
So the bill seeks to limit the amount of personal information.
I read that, yes.
Yeah. So from an industry perspective, what information do landlords genuinely need to be able to assess applicants? And
Look, I think quintessentially in other respects, and I don't know why it's being viewed differently when it comes to the housing market, but there's an obligation for example, for banks not to undertake predatory lending practices. And to do that, they need a particular amount of information. And yes, it might be uncomfortable for your bank when you apply for a credit card for them to ask you how much do you earn, have you got a pay slip, have you got all this information. But at the end of the day, they have a duty of care not to lend you money that you can't repay. And everyone accepts that. And it's no different in the housing market that, you know, there's a duty of care and obligation on property owners and their agents to make sure that if they sign a lease with someone and that person ends up living in a particular property that they manage or they own, that person has capacity to pay the rent and meet the obligations to which they've been bound. And I think at the very minimum, if you think about what information do you need to make that decision sensibly as a property owner, and we're talking here about the property owners as well, because the agents go along and collate the information and ultimately give it to the owner of the property and say, here's 3 or 4 applicants that we think are pretty good, which one of these would you like? And in order to make that as an informed decision, you have to know how much do they earn, if they've got huge financial obligations, those kinds of things. At the very least, you would want to see, well, they earn a particular amount of money, do they have savings, do they have a pay slip that confirms their level of income.
And they are who they are, and they say they are, because we're now in the world of scamming, as we know, and it's very easy to forge documents, digital documents as well, and we need to know, and property managers need to know, that person applying for a property, the owner's taking a risk here of letting a total stranger into a rental property. But they have a right to vet them, and they need to collect ID, and they need to know that they have a job, and they need to know that the past rental history is clean, and they need to know if they have an animal.
Yeah, and it's not in anyone's interest, including the tenant's interest, if they're permitted to rent a property that is beyond what they can afford. Like that's not going to be a benefit for the property owner. It's not a benefit for the tenant, and it's not a benefit for the agent that's involved and has to now manage this situation. So I think, and everyone's cognizant that, we want to share as little personal information as possible, and that I think is not an unreasonable thing or an unreasonable aspiration, but the information that has to be shared in order to make a proper informed decision, it needs to be adequate to determine, well, the incoming tenant, do they have capacity to actually pay for the commitments they've made? It's no different to You know, I booked to go to a restaurant with my wife the other day, and they asked me for a credit card and to pay $50 in case I don't turn up or whatever. And to be honest, I resented doing that. But I can understand and sympathise with the restaurant why they do it. And you know, there's an element of that you know, someone makes an application. That doesn't mean that they've, you know, in the same way that people you know, the banks and other institutions have these predatory lending obligations and a duty of care, and just because someone has applied for a credit card, it doesn't mean that they've got the financial capacity to repay that debt. And it's no different with rental properties. Just because someone's applied for something that's $5,000 a week, that doesn't mean that they have the capacity to pay for it, and there's an obligation on the property owner to confirm that they do before they agreed entering into this arrangement.
So you would say that the privacy reforms themselves are reasonable, but it's the regulatory burden is becoming excessive. Would you agree? Or?
Not really, no. We don't think the privacy bill is reasonable at all.
Okay.
When they impose $49,000 penalties on non-compliance, what penalties are there for tenants in this bill, or any bill for that matter, in the Residential Tenancy Act? None.
Okay.
Yet the agents, the landlords, property owners carry all the risk, but are not allowed to vet tenants anymore, as far as this bill is concerned.
Okay.
They're the ones taking the risk.
So in your view, would you say that this bill would discourage investment in
100%.
say rental housing? And what evidence would you put forward to
Look at Victoria.
Look at Victoria.
Yep.
Okay.
Over a 30% decline in rental stock.
Since the
introduction.
Yep,
introduction.
very similar to this that's on our tables.
We watch it very closely because ultimately that's what we're experiencing. Our rent rolls are depleting at the moment because of people getting fed up and selling. They can earn more money in a term deposit than what they can on the return of their investment property. So why take the risk? And more legislative change that gives them uncertainty or lack of choice in their perception will result in more people selling property.
So what would you say, or what amendments could be applied to balance the privacy protections and maintaining rental supply?
Well, they're two different things going on here. We know by evidence and our own modelling, if you like, and so forth, that the more regulatory compliance that is placed upon the property owner, the higher the risk means the higher the cost, but also means that owning a property becomes less desirable because of all this red tape, compliance, risk, costs. So anecdotally, evidence is there already that such harsh reform means that property, we know it's housing, but property is also an investment. And right now, the investment isn't looking like a very good investment if these are the rules and regulations to play within, as evidenced in Victoria market with a mass exodus. And we do have an exodus in New South Wales as well.
Okay.
Can I just jump in to add to that? I think everyone seems to get lost in this like us and them mentality that, you know, tenants are this and that and landlords are this and that and they're all butting heads, and in reality it's actually, I think the reality is quite different from that, and I think a lot of commentators don't quite understand this nuance that the vast majority of people that own investment properties, mum and dad investors, I think the stats are it's like 75% of owners have only one or two investment properties. So you're talking about a cottage industry with a very large number of very small players. That's the starting point in the context of all this. And the thing is that those players, what you've got to do is picture how do they make decisions. This is like a mum and a dad, you know, middle class people that might have some surplus savings and they think, where are we going to invest this? And those are the investment decisions that actually drive the entire rental market. And making changes where you're doing things like introducing penalties of nearly $50,000 for a non-compliance, when you introduce that, there won't be an immediate reaction. Right? There's not that many, well, there is no industry body that ties together cohesively every single little cottage level investor. The POA does a good job with our members, but But there's a whole industry of cottage investment, and what will happen is it takes time. It takes, when someone gets a $49,000 fine, that mum and dad investor then scratch their head and think, will we buy another investment property? Probably not. Will we sell this one? Will we invest in the share market where there's less risk? Like, these are not big, highly capitalised investors, and it will take time for that change to flow through to investment decisions, because by nature they're slow moving. No investor really looks and says, oh, there's been a change to the tenancy law, I think I'll sell my investment property. It takes time for that. They have to have a bad experience at NCAT, they have to have other things go on that lead up to it. And in that way, it's taken 30 years of policy to get to the current undersupply that we've got, and it'll probably take 10 years of good policy, if you start right now, to fix that. And to imagine that you can make a few changes to the tenancy laws and that's going to fix it, I think that's wishful thinking. And I think those investment decisions, they take time to bleed out. And if you make decisions now, the reality is that worsen it and make it less attractive. It's not going to lead to a dramatic change that'll be visible tomorrow, but it will just add to the weight of things that have caused the investment decisions that have gotten to where we are. And 10 years from now, it will be worse.
I'll change tack. So some stakeholders argue that landlords would be better placed to manage the tribunal process rather than, say, the renters. What's your view on that? In terms of, with pet applications?
I think in terms of the interactions that happen at NCAT, and I don't have the stats in front of me, but because it's a cottage industry, very few of the players that are involved are regularly in front of NCAT.
Yep.
Again, we're not talking about big corporations. If you're a mum and dad investor and you have one investment property, the reality is over 20 years you may never have a matter that is before NCAT. So I think the level of stress and anxiety that happens is equal on both sides.
Okay.
So that's the first thing. And I think this is going back to the characterisation of our landlords. They've got lots of money. They're big fat cat property investors. They've got the money to engage lawyers and to deal with matters at NCAT. I think that's an error of judgment and a mischaracterisation of the industry. I think you'll find the people that I know who have owned an investment property and have had a matter before NCAT for any reason have found that incredibly stressful. They're on, obviously anecdotally, but the people I know have been on tight budgets and found that incredibly stressful. And I think it's an unfair characterisation to say, well, one party. I think both parties, to be honest, would be new to the NCAT process.
Yeah. Okay. I think we're out of time.
Yeah, we've gone quite over time, but I haven't given the government any time if you wanted to jump in with a...
Oh, look, I mean, I suppose if we sort of get back on point in terms of we're dealing with a bill where there's been amendments proposed, and I think we've discussed a couple, but I just wanted to get your view on, in particular, the proposal to give renters 30 days to rehome a pet after the landlord's refusal or NCAT makes a decision. Quick view on that.
I think the previous bill outlined the legitimate reasons why an owner can reject the application, and I feel that if those are legitimate reasons, then I don't see the necessary for the 30 days. I mean, there is the NCAP appeal process, which the tenant has full rights to do so. And as far as I understand, again, the statistics we see is that there's not been one case that an NCAT hearing has heard that hasn't weighed in the favour of the tenant. So really, there's no risk to a tenant to number one, go through with the process to go to NCAT if they feel that they've been discriminated against. Number two is that I don't think if there's a legitimate reason for the pet approval to be rejected, that there should be an extension of time frame to rehouse the animal. Again, this in my view fuels back to concealing the fact that you have a pet while moving into a new tenancy agreement is causing more of these issues than what it would be if they were up front at the start, and most owners would be happy to approve it at the day one.
What about allowing the pet to stay in the rental property while NCAT makes a decision after a landlord refuses a pet?
Look, I understand there's complicated scenarios there, and that might be something that needs to be legislated a bit more. I guess that would be fair in respect to until the ruling's being heard by NCAT to allow that period of time. But then it opens up other windows of problematic in regard to damage to the property. Does that mean that the tenant's core lease is affected by the pet being in the property for that period of time, and the tenant would then need to make remedies to correct the property in such instances? And definitely I think that's something that needs to be further debated.
What if a pet is in a strata property and you've got two neighbouring apartments, and that particular pet is barking day and night, and you've got a mum living next door with a newborn that can't sleep at night?
Yeah, there's nuances. Yeah.
Is your concern the time frame, or the concern of a property owner making decision that pet is no longer suitable in that property?
Yeah. No, it's a fair enough point. What about allowing renters to terminate their lease with no penalty if a landlord refuses a pet application?
See, again, it comes down to concealing the fact that you've got the pet at the start of the application process, because that wouldn't be an issue if that was the case. My view is the landlord in good faith has accepted that applicant. Now they're coming back with a pet request, and they knew that they had the pet obviously at the start of the tenancy. And then we're going through the same answer as before. There are already outlined reasons, prescribed reasons, why the owner can refuse the pet. Now, if we get past that and it's awarded that yes, that pet can be refused for legitimate reasons, why would the landlord have to incur the costs of allowing the tenant to break their lease, a legal document, to say that they've got security for that period of time?
Yeah.
And what about the compensation? I know in the bill it talks about economic compensation for people that are affected by things. Does that mean that the landlord then has a case against the tenant for releasing the property if they're out of pocket for the transaction?
I know you covered off on the advertising one. What about, I'm not sure if he did this one, extending the grace period from 7 to 14 days?
Again, in my view, it branches the whole problem from the not disclosing at the point of application. 7 days, I think, if that's what it needs to be, is ample. I think extending it any further risks further confusion moving forward.
All right. Thanks.
Thank you. Well, thank you for giving your time today to give evidence. I note that owing to the extremely tight time frame, I don't think anything was taken on notice, but we do have a very short time between the hearing and the report deliberative. So there's a very tight window for any questions taken on notice. But I can advise that the committee has resolved that any transcript corrections that you want to make, any questions on notice, any clarifications of evidence that witnesses want to make, and any additional information that you want to provide the committee has to occur within 24 hours on receipt of the transcript. And the Secretariat will be in contact with you in relation to any questions on notice, but also to provide you of that transcript from today's meeting. So thank you again for your time, and we will now break for lunch, and the committee will be back at 2:30 p.m. sharp.
Thank you, Chair.
Thank
you, members.
you, committee.
Thank you and welcome back. Could I begin by asking each witness to please state their name, position, title and swear either an oath or an affirmation. I'll start with the witnesses in the room.
My name is Rashika Pai. I'm a board director at Lucy's Project. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Hi, thanks for having me today. My name is Livia Stanton. I'm a Senior Policy and Advocacy Officer at Domestic Violence New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
And hi, I'm Rhiannon Cook, Acting Deputy CEO at Domestic Violence New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms Ludwig?
My name is Anna Ludwig. I am the founder of Lucy's Project and I do solemnly affirm that I will tell the truth, the whole truth and nothing but the truth.
Thank you. Do we have a short opening statement from Lucy's Project?
Yes, thank you.
Thank you.
My name is Rashika Pai and I'm a board director of Lucy's Project. I'm joined by founder and acting CEO, Anna Ludwig, by video. Thank you for the opportunity to appear today on behalf of Lucy's Project. Lucy's Project is a national harm prevention charity focused on the intersection between domestic and family violence and animal abuse. Our work seeks to remove barriers to safety for victim survivors who have companion animals through research, advocacy, collaboration and education. Research shows that animals are often present in households experiencing violence. Approximately 70% of Australian households have companion animals, and concerns for those animals can significantly affect victim survivors' decisions about leaving. Perpetrators of domestic and family violence often threaten, harm and kill animals to control and intimidate women and children. Research suggests that up to 68% of victim survivors with animals delay leaving a violent situation because they fear for their animal's safety. A 2020 Women's Safety New South Wales report found that 96% of frontline workers identify lack of pet-friendly rental accommodation as a major barrier to long-term housing. Lucy's Project therefore strongly supports tenancy frameworks that reduce barriers to housing for people with animals, particularly for victim survivors of domestic and family violence. In our submission on this bill, we recommend extending the 7-day grace period to keep pets while tenants await landlord consent, and we recommend where consent is refused, tenants be granted a minimum 30 days to find alternate accommodation, and tenants be allowed to terminate a tenancy without penalty. We recommend improving transparency in rental advertising where animals genuinely cannot be kept, and we recommend reviewing the current pet application process as a whole, such that the onus of consent for pets is shifted from tenants to landlords. We welcome the opportunity to answer questions and assist the committee in considering how tenancy laws can better support both people and animals experiencing violence. Thank you.
Thank you. Is there an opening statement from Domestic Violence New South Wales?
Yep, I'll start, and I'd just like to acknowledge that we're on Gadigal land and pay my respects to elders past, present and emerging. Domestic Violence New South Wales is the peak body for domestic and family violence services across New South Wales, and we have over 200 member services. We also thank you for the opportunity to provide evidence today and for this inquiry. As a domestic violence peak body, we strongly support reforms that better protect the personal information renters and prospective renters are required to share, particularly victim survivors of domestic and family violence. So we welcome the changes in this bill that would reduce the pressure to hand over excess personal information and give victim survivors stronger tools to access, control, correct and delete information that could put them at risk. So thank you for the work on this bill to date. However, we do want to raise some issues that we think could have unintended impacts on renters with pets, including victim survivors. We know that women and children who are escaping domestic and family violence often need safe housing fast, and the private rental market is hard to navigate. They often need to make decisions under lots of time pressure. When you add affordability, housing shortages and highly competitive applications into the mix, these things can make it harder for women and children to leave a violent relationship. So our recommendations are really aimed at trying to make it a little bit easier for women in this situation. And I'll hand over to my colleague Livia to talk about those recommendations.
Thanks, Rhiannon. So our recommendations really are responding to the major barrier where many victim survivors delay leaving because of fear that their animals will be harmed, and too often this leads to unsafe housing choices or the distressing decision that victim survivors must sometimes make to surrender a pet. So we recommend 5 practical changes to make the pet process fairer and safer for tenants. First, if a landlord wants to refuse a pet, the landlord, not the tenant, should have to apply to NCAP. Second, extend the current 7-day period to 14 days so tenants can move in with their pet and seek consent at the start of the tenancy. Third, if a pet is refused, tenants should be able to end the lease without penalty and have 30 days to find alternative housing. Fourth, landlords should disclose any known reasonable grounds affecting pets at the advertising stage. And finally, if a landlord fails to disclose those grounds and later relies on them to refuse a pet, the landlord should cover the tenant's reasonable moving costs. Together, these changes would give victim survivors clearer, faster and fairer pathways to secure safe housing with their pets, reducing arbitrary refusals, preventing avoidable moves and costs, and removing a key barrier that keeps people trapped in violence. Thank you.
Thank you. If I could start with a few questions, and I think I'll direct this to both organisations, so please jump in whenever you feel comfortable. In the last session, we heard from the Property Owners Association of New South Wales, and we also heard from Real Estate Institute of New South Wales. And their argument was that everybody, even if they are attempting to leave a violent situation, should just declare up front if they've got an animal and then no worries. Can you explain what the problem is with that, particularly for people trying to leave violence, and why that isn't such a good solution?
I can start if I may. I would say, first of all, the problem is we know that currently isn't working for victim survivors. Victim survivors know, from the current situation and their own life experiences that, they are being discriminated against in the rental market because they have pets. And so it's not safe for them often to disclose that they have a pet because they know that they'll be rejected. We hear time and time again from our members that this is a significant barrier for victim survivors to actually leave violence, particularly in the regions where we know that pet ownership is much higher. We know that the types of pets that people own, are bigger. We're not just talking about, a rabbit or something like that. And so if it's up, if the onus is for the victim survivor to just declare that, what protection is there for them in doing so? Currently, the way it works is that, the landlord can simply decline that on reasonable grounds. And so we want to ensure that there are protections up front for victim survivors so that they can actually have a fair experience accessing rental properties.
Thank you. Does Lucy's project have anything they wanted to add to that?
No, I'll just add to that. Look, I agree. I think there is a bias against renters who have animals. I don't have data around that, but I think there seems to be a bit of a cognitive dissonance between, people might be animal lovers. I'm a landlord and I'm also now a pet owner. And when I first started renting out my property, you see one application with pets, you see one application without pets. And even I, at that time, it gives you pause to think about who you go with. And there's no oversight of that, no oversight of how landlords make decisions. It's not regulated in any way, and I don't see how it can be regulated. So I think that, despite being an animal lover, pet lovers, people might have their own pets, but there's nothing stopping those landlords from, intentionally or otherwise discriminating against someone someone who has pets, and they have no idea who the applicant is. That might be someone fleeing a domestic violence situation. That's private information. You would never know that. So it's just really difficult to confidently say that disclosing a pet on an application wouldn't result in some form of discrimination, or that that applicant not being chosen when compared against other tenants.
Thank you. Under the bill, a tenant will have a 7-day grace period to apply to keep an animal. And if that application is refused, they have to immediately remove the animal, or they're in breach of their lease, even if they're planning to go to NCAT to challenge that decision. How practical is that for somebody who has just left a violent situation and now is in a rental property with their animals?
I might go ahead. So I think that puts a victim survivor in particular in a very difficult situation. They might have fled a relationship with a lot of difficulty. We know that it takes a victim survivor many times to successfully leave a violent relationship. I think the stat was 68% of victim survivors delay leaving out of fear for their animal safety. So if someone's taken that step and then is told, well, you can't have that pet at this property, I think the risks, there's a few risks there. One is they're forced to surrender their pet, and we know that pounds are full, rescues are full. What alternatives leave a victim survivor? It might be euthanasia, it might be returning the animal to the perpetrator. They might feel that's their only option, or it might even involve the victim survivor returning to the perpetrator. So I think there's many risks in that, and we need to have a framework where a victim survivor has these options. It's a part of safety planning to, look at where a woman might go. Refuges are full, or they may not have they may not be pet friendly, and so I think it's really important that we do all we can to make sure the tenancy framework provides women with safe and appropriate housing alternatives.
Yeah, I would just add to that and say, I think, we know from what our members tell us that a lot of women would rather stay, in violence or face homelessness than have to give up their pet, because their pet has been the one stable thing, throughout the violence, the one thing that they've been able to rely on, that has given them comfort, that's given them hope, that's given them companionship. And an expectation that they should give up this pet is unreasonable. It's not really humane either to ask a woman going through that to give up a pet. As Rashika has said, women are under immense pressure when they make these decisions. And they don't make these decisions to leave quickly. It happens over a long, very long period, and there's several attempts to leave, and there's been a lot of careful planning usually to do this. And so for a woman to then find herself in a new rental where, wow, she's arrived with her pet, she's safe finally, she's away from the perpetrator, and then to find out that she cannot stay with her pet there is just absolutely devastating for that victim survivor, and the impact that can have, and that decision that woman now has to make is impossible. And that's why we are recommending for upfront disclosures for real estate agents on, whether or not this place is pet friendly. Are there certain elements of the property that mean you can't have a dog, or you can't have this kind of animal, but it really should be disclosed up front so that, victim survivors aren't going in blind, because it's not fair on them, and it's not safe.
Another suggestion that's come up this morning is if the tenant wanted to break the lease, if the animal was refused, that there'd be no sort of financial penalties around that. Is that another thing that you would support if someone was in this situation? So that, I guess another major issue for somebody that's left violence and has found this rental accommodation, and they do need to find another accommodation for whatever, difficult reason, that, they don't have some major cost for actually having to break the lease.
Yeah, I mean, absolutely. I think if the expectation is now that the tenant has to leave, and yet there's no transparency around the fact that this property wasn't going to be suitable for a pet, then, you know, the landlord should have to pay the moving costs, reasonable moving costs, absolutely. Otherwise, it's, you know, the fairness and the tipping point is all in favour of the landlord. And, you know, for renters, that's just not fair. And we know we're now living in a state where more and more people are having to rent because housing affordability is, you know, so out of control. These laws are going to become more and more important into our future as we see more and more people, you know, having to rent as opposed to live in their own home.
It's been suggested, and I think in Fair Trading's submission they suggest that tenants should be the ones proactively considering factors that could affect an animal's application, such as council bylaws or whether the landlord actually lives at the premises, and that it's on the onus of the tenant to sort of find that out. But I note in the submission, particularly by Domestic Violence New South Wales, you point out that victim survivors have to make decisions affecting their safety, often under immense time pressure. Is it really appropriate for anyone to expect the tenants themselves to actually have to do that investigations before even making a rental application?
Absolutely not. That doesn't make any sense, I think, to me, as to why that burden would sit with the tenant. Why, you know, I think the landlord should have to disclose up front. Yeah.
I'll just add to that I agree. Definitely shouldn't be, that burden shouldn't be placed on the tenant. They, you know, in particular, victim survivors might be navigating multiple issues, you know, financial instability, homelessness, navigating AVO proceedings, family law proceedings, fleeing a relationship, you know, relationship breakdown. It's the last thing that they would have on their radar is looking at those types of issues. Same with navigating NCAT, which I'm sure we'll get to.
Thank you.
And just to add to that, it is very likely that women in this situation are applying for more than one rental property. So that would mean that we would be asking them to look at bylaws across, you know, multiple properties. So it's not just, whereas a landlord would know what their assets are, and that information wouldn't change, you know, from one rental period to the next.
Thank you. And just sort of more broadly, before I throw to Ms. Abigail Boyd, you know, we've sort of got these two pieces of legislation that have sort of come to us. The first one, unfortunately, put the onus on the tenants rather than the landlords. And now we've got this second bill in front of us, which is proposed to, first of all, ensure that people who are applying don't have to declare that they've got a pet, which I assume you support, and I'd like to hear the reasons for supporting that. But also, there's these complicating factors with this new change in that, even if someone's applying to NCAT, that the animal has to be removed immediately. Can I just get your thoughts around the change, that they don't have to declare potentially that there's a pet in the application, but then also some amendments that you would like to see in regards to this bill, and some of the most important amendments to ensure that people who are seeking rentals, leaving violence, are not unfairly discriminated against?
I would say to the first question, around whether or not victim survivors should have to disclose
or
the pet.
Anyone,
or anyone, sorry.
Yeah.
I think they shouldn't have to. I think that really should be the whole point of this legislation, is to protect renters so that, they're not having to disclose something and, have unfair decisions made about that. I think we've talked about a lot of those reasons why, but particularly for victim survivors, with the things that they're already navigating, and Rashika touched on all of that. what that really looks like in reality for a victim survivor is extremely complex, and you know, they may be working with a support service or they may not. They might be navigating all of this on their own, including, you know, apprehended violence matters, family law matters. There could be, you know, children involved where they're shifting schools, and you know, they might be having to, you know, relocate and hide from a perpetrator for their safety. And we're really, you know, when we're talking about relocation, we are talking about life and death sometimes. So I think it's really important that we state that clearly. And so, you know, having a pet just shouldn't come into it. It shouldn't be a reason that the landlord can say no, unless it's very clearly articulated at the time of advertisement that the property isn't appropriate for pets, and you know, the reasons why.
Mm-hmm. I see Anna Ludwig's got her hand up.
Thank you, Anna Ludwig, Lucy's Project. Thank you so much. I thank my colleague Rashika for her honesty in sharing her own personal anecdote of experience of being a landlord. And can I just say Lucy's Project has sustained almost 10 years of research in this field as well, and heard repeatedly from landlords and from real estate agencies and peak bodies that it is often the landlord that has the prejudice against animals because of a public perception that animals are going to cause damage to rental properties. But that's actually not sustained in data, and it's not sustained in experience. What tends to happen is when there is an example of an animal causing damage in a property, it tends to attain more attention than the cases where it has been successful. So there is a negative perception that is not actually sustained by experience or from any documented evidence. And my colleague was completely right to point out that that is puts the landlord in a position where they feel like they have to make a choice between the best interests of their property and their property potentially being put up for damage, where it has there is more evidence that a person who has a pet is very grateful for the experience of having the safety of having their animal with them, and is more likely to take extra care of their property and to be very respectful of that property for fear that that will have a negative image or impact on the property or the image of their pet that's in their care. So I think it's incredibly important that we reduce that stigma. It's something we've tried to do through advocacy, and I think that it's something that could be really backed up by having some legislative protection so that we can rid once and for all that image of the animal being something that's going to cause damage to a property. We wouldn't put that burden on children, and we shouldn't put that burden on animals either. People deserve safe housing. This is a fundamental requirement of human nature. I can also say that we need to be very cognizant of the amount of pressure that is on these people at that time, and any punitive time impacts when we're thinking these people might have for the first time in many, many years have initially found safety, to ask them to turn around and have short turnaround periods for finding and securing that accommodation for the longer term is unreasonable, unjust, and as others on the board have said, is manifestly unfair.
Mm. So one of the main recommendations that you'd like to see is that change in the amount of time that people would have potentially to move, as well as and as well as sort of advertising beforehand, so that people are aware if there is a specific reason why that property is actually unsuitable.
Absolutely, that is logical. If there's, as my colleague Rhiannon said earlier, that would be something that is known to the landlord in advance, unlikely to change. If it does change, there's no reason that they couldn't give notice of that for whatever reason, and it's an unfair onus to put on a person who is already heavily burdened by the responsibilities that they've had to secure safety for themselves and often their children and for their animals during a period of incredible emotional and administrative burden.
Thank you. Is there any other amendments that anyone wants to discuss as well that we haven't gone through?
Just the overall sort of broader recommendation to look into shifting the onus from tenant to landlord to apply to NCAT. I don't know if you want to expand on that, but that's something that Lucy's Project advocates for, for various reasons. I'm happy to go into them if needed. But.
Thank you.
Yeah, we would support that too. It's our first recommendation. I think it's kind of forms the basis of all of this work is the onus must be on the landlord and not the tenant to make the system fairer for everybody.
Thank you. Ms. Abigail Boyd.
Thank you very much, Chair, and good afternoon to all of you. The Chair has stolen most of my questions. Well, not stolen. I think she very fairly came up with them herself. But just on that last one, it's interesting, the witnesses we had before, particularly I think it was one of the witnesses from the Property Owners Association and Real Estate Institute of New South Wales, Mr. Partridge it was. He said, quote, "There's no risk to a tenant to go through with the NCAT process," end quote. Now, when we're talking about tenants who are, or prospective tenants who are fleeing domestic family violence, it brings these issues sharply into relief. But you would imagine that there is, for a lot of tenants in a lot of circumstances, NCAT would be quite a worrying process to go through, or even a inaccessible one. What can you explain, I guess, why in the context of a domestic and family violence situation, that putting the onus on the tenant to go to NCAT is even crueler? Can you explain what that means really for a person who's trying to get to safety?
Yes, thank you. So, look, I think the average tenant, regardless of whether they're fleeing violence, would be intimidated by NCAT. I've done it myself over, just a bond, and it was stressful, extremely time-consuming, and my day-to-day job is a solicitor, and I'm familiar with, courts and tribunals, so I can only imagine, like I touched on before, a victim survivors navigating potentially multiple jurisdictions. They have no choice but to, AVO proceedings, often family law proceedings over kids and property, and to then throw NCAT into the mix, which, I wouldn't see them having the capacity a lot of the time to wish to do that, and that can result in, as we spoke about before, poor outcomes for animal welfare and the tenant themselves and their children.
I would just add to that, look, we've just heard it from a lawyer herself and her process going to NCAT. I would say that for a victim survivor to go to NCAT, probably a lot would just rather not, and wouldn't actually go through that process, would rather leave the property because it's too traumatising. NCAT officials are not trained in domestic and family violence, so that's another key recommendation we've made through other consultations as part of the DV provisions within the Residential Tenancies Amendment. But yeah, it's not an appropriate kind of pathway for victim survivors to have to take with everything else that they've got going on. We absolutely think that onus must be on the landlord.
Thank you. I think one of the statistics, and I can't remember the exact percentage that those sort of representing landlord interests were throwing about before, but you often hear this idea that I think it's like, I can't remember, like 3 in 4, even more, landlords only have 1 or 2 investment properties, and trying to make it out like it's some sort of cottage industry, this mum and dad thing, when the reality is that we're looking at 51% of all rental properties being owned by landlords that have far more properties than that, 3 or more. So in those circumstances, if you're a person fleeing domestic family violence, where, as we know, it's often there's been this pattern of coercive control, and really that moment of leaving and trying to get some autonomy, the idea that you would then have to go and take your landlord, who is likely to be one of these multi-investor landlords and has a lot more money than you and a legal team and all sorts of things, to NCAT sounds a bit extreme, I guess, in that scenario. Do you have any experience or any case studies of helping individuals in those sorts of circumstances, or any other kind of insights into that sort of process?
I'll clarify for the record, when I went to NCAT, it was as a tenant, and the landlord sent their real estate agent, and it was, $600, and, it's... so no, I don't have any other experience apart from that anecdotal experience in relation to navigating NCAT. I don't know if you guys do.
Yeah, we don't have any particular case studies, but I think, Abigail, when you talk about, the plight of the investment property owner, I've got to say, housing is a basic human right for everyone, whether you're fleeing violence or whoever you are. Everybody deserves access to a safe home over their heads. And I think most landlords would feel that way, that, everybody deserves a safe place to live. And we know that for victim survivors, the main barrier to accessing safety is somewhere to live. And so if you add pets into the mix and you add these complex laws, NCAT on top of that, it's extremely complicated, and it really just shouldn't be. It should be simple, because we're talking about a basic human right here.
Very nicely said. Absolutely. And I guess, yeah, you've said it all. But I think that if you were to say, when we were speaking with the landlord, sorry, I should actually say who they were, but you know who I'm talking about, who were here before. When we were speaking with them, they seemed to present this idea of there needing to be choice for landlords. And my instinct was to think, well, yes, you could just not have an investment property if you're finding it that stressful to get a tenant. Whereas a tenant looking for a prospective tenant looking for a house doesn't have those choices. So maybe it's just more of that sort of balancing of interests. But yeah, you've said it very well. It's a fundamental human right to have some shelter over your head. Thank you.
Thank you. Ms. Aileen McDonald.
Thank you. I'm wondering, in your experience, when a victim survivor has to relocate or move, how often, would they have to do that because they've been refused tenancy because they've had a pet? It's not just a one-off experience, would it be?
That's a good question. I don't have data on this. I'm not sure if there is data available. Do you know?
No, it's really, like I said at the start of the hearing, it's hard to know what drives a landlord's decision to refuse anyone, I think. So unfortunately I don't have data on that either. Okay. I don't know if it exists.
Because then you would think that if they had to repeatedly relocate because they weren't allowed to have their pets there, that would probably put them at an increased risk of returning to a violent situation, or not even leaving, knowing that they're going to have their pet refused.
Yeah, absolutely. I think there is that link there, and something we haven't touched on is the link between violence against animals and violence against humans, and there's studies on that. People who abuse animals are more likely to abuse people, and also threats or harm to animals is recognised as a risk factor for severe domestic violence and homicide. So I think that's just really, the what drives us in, doing our advocacy and things like that. And just in terms of just touching on what we were speaking about before with the property associations, sorry, I forget the name, the landlord associations. We're in a domestic violence crisis, also a rental crisis, and I think we do need to prioritise the safety of victim survivors, who include women, children, animals. 70% of Australians have pets. We live in a community who love their pets and their companion animals, so I think that needs to be the forefront of decisions around tenancy framework.
Just to let you know, Ms Ludwig has her hand up.
Okay,
Ms
sorry.
Ludwig, did you have a further answer?
Yeah, I just wanted to talk about the statistics around people refused tenancies because of their animals. I think that would be an incredibly difficult statistic to ever be able to measure. I live in the Northern Rivers of New South Wales, an area where whenever there's any availability, particularly one that is pet friendly, there might be hundreds of applications. And knowing exactly why a person has been refused that application might not be immediately obvious to that person, but I know that my friends, my community with animals, when they do apply for a tenancy, they know that they've got next to no chance, and they're desperate, absolutely desperate for accommodation and forced into completely inhumane situations, which then often, unfortunately, has led some people to lie about having animals, both on their application and moving into a tenancy with an animal and then hiding that animal for inspections, which unfortunately, if that has led to an eviction, would that person who has brought the animal in contradiction of the terms of their tenancy is seen as a person in the wrong. So it's unlikely that we're then going to be measuring those statistics as a person who's broken the terms of their rental agreement. So those statistics are going to be really hard to come across. But what we know is what we want to do is be reducing as far as possible the unrealistic situations that people, particularly with children, where that animal might be a companion or a support for the child as well during domestic violence. We want to reduce those barriers that family is going to have to safety for the reasons that my colleagues have so articulately explained.
And then I imagine when you're dealing with, say, frontline services to talk about, hey, I'm wanting to leave a violent home, I would imagine that in that discussion they take into consideration companion animals as part of that safety plan. But then in doing so, does the current, say, rental restrictions make that planning more difficult? Or
Absolutely.
Yeah.
Absolutely. Lucy's project is dedicated to removing those roadblocks to safety and to making those pathways to safety easier for and better known for people to reach safety, to reduce the amount of times that a person is feeling compelled to return to an unsafe home. This is one of our key focuses, to increase the efficiency and to reduce the impact on women and their children that are fleeing domestic and family violence.
Yeah, and I would add to that, I used to work in the frontline services as well, supporting victim survivors of DFV, and it was always a key component of safety planning, and it's still what we hear from our members today, that women with pets are severely disadvantaged in terms of what's available to them, where they can go. There have been some positive steps in that direction. For example, there are new core and cluster refuges that are built largely in regional New South Wales, many of which you can take a pet. But we're still quite behind when it comes to the rental legislation, and so these reforms are really important and really key to the safety of victim survivors.
And you've already mentioned, say, the trauma or extra stress placed on people when, say, if they've then having to deal with, that navigating that NCAT process if the pet is refused. And what are the other barriers besides, legal knowledge or time and their emotional capacity to deal with that NCAT process?
I think trauma would be a big part of it. Putting someone back into contact with court processes when they might be already traumatised from doing that in a space with a perpetrator, like the local courts and the family courts. Putting them back in a court environment, I think, would be really traumatising. And I just, like I said before, I think there'd be a lot of difficulty in them even wanting to do that and take that step.
And I think there's evidence. The science tells us that brains under trauma are less able to process information, particularly new information, and engage in a process like that. So it's not just that there's too much going on and it's too much of a burden to handle the additional administrative load. it's the brain's capacity when one is, experiencing significant trauma. And when we're talking about domestic and family violence, for some of those women, that includes brain injury. And for many of those women, it's undiagnosed brain injury, where we know that, being able to, cognitive processing is not just delayed, but, not always possible and not functioning, in the same way that it was previously. So, these are real concerns for victim survivors.
Yeah. Do you think in developing, say, this bill, that department has talked to, say, Department of Women or Prevention of Domestic Violence to try and align some of the key components, or done in isolation?
I don't know that we're able to comment on government processes, but we do hope that the different departments are talking to each other.
Yeah, okay.
I just noticed Ms Ludwig had her hand up for the last question.
okay,
Did you have
sorry.
something to add to that, Ms Ludwig? Sorry.
No, I think Ludwig Lucy's project. No, I think Rhiannon said a lot of the points that I was hoping to also say, but I think I was just wanting to, I suppose, reiterate the incredible burden that is on women at that time in those early days of being in dealing with domestic and family violence. But also, as a single mother, I can say this, but also thinking of the fact that most of these people in situation will be single mothers, trying to find childcare to even attend an NCAT hearing, or to have the mental space without the child to be able to attend those hearings is a really unrealistic burden to place as an additional burden on those people at that time. Also, one of the things I'm reflecting on is that when I have had conversations with people during the process of experiencing violence and safety planning, the mental burden on them is intense. And one of the most supportive things that we can do is to help make that process easier by doing some of that thinking work for them in advance, because it is just such a burden. And as Rhiannon so eloquently put, we need to also think about the mental, the physical, and the acquired brain injury traumas that person might be experiencing. Violence has impacts. So I think most of what I wanted to say has been said very eloquently. Thank you.
And sorry, I just wanted to add as well, the sector and the peak bodies have been consulted quite a lot on the DV provisions within the residential tenancy amendment. So it hasn't come out of the blue. There has been extensive consultation over the last few years, and obviously that's taken into account, all parties, and so, that's why we're here today, ultimately.
Yeah. And you just mentioned before, say children. How important is it for children to be able to keep the family pet? Knowing that they're leaving a violent situation. They're usually silent witnesses, so there's that component as well.
Well, we would actually say that children are victim survivors in their own right, not just silent witnesses, although they do witness a lot, and sadly they're often not placed at the centre of their own story, and they don't get the same wraparound support often that the adult victim survivor receives. We know that pets are a really important element of any family for children as well, and that relationship with the pet might be a really special one. But if we take a step back as well and look at children's experiences, I guess, in that context of domestic and family violence, we know that the long-term outcomes for children that experience domestic and family violence, are that there are really significant impacts, including, impacts on mental health, ongoing trauma, impacts on being able to form a secure attachment later in life, good social and emotional development, all sorts of kind of long-lasting consequences. And so if the mother or the parent is delayed from accessing safety, then the child is in that violent home for longer. And if this is all coming down to something as simple as allowing a pet to be in the property, then that's what we need to do.
And I'll just might add to that like Livia said, companion animals play an important emotional role for victim survivors and their children who are victim survivors in their own right, and that bond can be exploited by perpetrators. If someone's looking to leave that relationship and they can't take their pet, and often they can't because of rental properties or various other issues, but if they can't take the pet at the time that they leave, which is such a crucial moment in time, it is really difficult to get the pet back, even if it's in the victim survivor's name, just from looking at the legal frameworks around family law, domestic violence law in New South Wales as well. It's really difficult. So just emphasising how important that point in time and a survivor's leaving to take their child, take their pet with them is really crucial.
Yeah. I think we've run out of
Thank
time.
you. I think we have. Ms Ludwig, I see you've got your hand up. Was there something you wanted to quickly add?
Just that children can attain joy from the animal in a crisis, and they might actually be the only support that a child has when a parent is giving their all to keeping the family safe.
Thank you. Sorry, does the government have any questions?
No, thank you, Chair.
Okay, great. Thank you. Well, thank you all for your time today and for coming to give evidence. We really appreciate it. Owing to the extremely tight time frame we've got on this inquiry and the report deliberative, there's actually a very limited window for any answers to questions on notice. But I can advise that the committee has resolved that any transcript corrections, any answers to questions on notice, any clarifications to the evidence that witnesses may want to make, or any additional information that witnesses may want to provide us, needs to be provided within 24 hours of the receipt of the transcript by the witnesses, and the Secretariat will be in contact in regards to that and provide a transcript as soon as possible. Thank you again for your time. Thank you.
Thank you.
Thank you.
Thank you, and I welcome our next witness. Can I ask you to please state your name, position, title, and state either an oath or an affirmation?
Thank you, Chair. Trina Jones, New South Wales Rental Commissioner, and I'll be giving the affirmation today.
Okay.
Thank you. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Do you have a short opening statement you'd like to make?
Yes, please. Thank you. I thank the Chair and the Committee for the opportunity to appear today, and I would also like to acknowledge the land on which we meet and pay my respects to the Gadigal people of the Eora Nation and the elders past, present and emerging. The private rental market plays a significantly different role in the housing system than it has done historically. More people are renting, and they're renting for longer. Many will rent for their entire lives. More than half of renter households are families with dependent children, and the number of older renters continues to grow. These shifts mean the rental sector is increasingly relied upon to support long-term, stable housing rather than short-term or transitional accommodation. I think that's well understood by the committee. Within this context, companion animals are a normal part of household life for many renters. However, access to rental housing for people with pets has historically been really difficult and constrained. Market data illustrates this very clearly. In financial year 2022, only 10% of rental listings allowed pets, meaning that close to 9 in 10 listings effectively signalled that pets were not welcome. While this increased to 13.9% in 23 and 14.6% in 24, the majority of rental properties continued to operate on the basis of exclusion rather than the merits of the individual suitability of a pet for that rental home. New South Wales renter reforms were introduced to address this entrenched practice by prohibiting the advertising of blanket no pet conditions and requiring pet requests to be considered on the individual merits and, as I said, suitability. Under the current framework, a pet may only be refused on very specific prescribed grounds. Where a request is refused, renters have access to not only the ability to contest that in NCAT, but also to come to fair trading. We've just stood up a mediation function in fair trading, and we're absolutely ready and willing to support renters and landlords to sort out any concerns they might have about issues like pets. And as I said, they can also go to NCAT where a matter is refused and seek a decision there. Early enforcement activity has also been undertaken. When the task force was stood up, one of the biggest focuses in the initial reforms was to look at no pet adverts. And so what we did was we looked at over 20,000 listings and did an audit on that, and were able to issue 123 warnings and over $3,000 in penalty units following that audit. And subsequent audits have shown us we've seen 99% compliance with that provision. Despite the reforms and the proactive and effective compliance efforts, the process for moving with the pet remains uncertain at the point of application. In a market with high competition for rental properties, renters frequently hesitate or don't raise pet-related requests out of concern that it may affect their ability to secure a home. As a result, pet ownership may be disclosed later once the tenancy is secured, or not disclosed at all. Now, this behaviour reduces transparency and actually increases the risk of disputes and misunderstandings, and that can put renters at risk of being in breach of their agreement should they not disclose a pet, creating unfurther stress for their tenancy. From a regulatory perspective, this demonstrates a very clear gap between the formal legal framework and how the system is operating in practice. The effectiveness of the current setting relies on this disclosure, the processes to be clear, and also confidence for both renters and landlords around the tenancy relationship. So the proposed provision under the amendment for the Protection of Personal Information Bill seeks to introduce a grace period to address the situation at the beginning or the application part of the tenancy, because this means that we can prevent tenants from being discriminated against potentially through this process. The grace period is to ensure renters are not in a situation where they have to either breach their lease right away after moving in, or essentially potentially reduce their ability to secure a rental home. Introducing the grace period can reduce some of the stress and promote a smoother transition for renters when moving rental homes. The consideration of a short, defined grace period for pets is directed at this operational issue. It's a very serious operational issue. It's procedural in nature, and it doesn't alter the substantive grounds on which a pet request may be approved or refused. So in this, we're seeking to strike the right balance for renters and landlords based on the extensive consultation we've done on this work to date. We know education is a key part of this, and this is something that we've been very focused on at Fair Trading. And the early engagement, dispute resolution and education have been the three main pillars. I've already talked a little bit about the stakeholder engagement, but we've spent a lot of time with pet advocates, tenant advocates, landlord representative groups across various reforms, and talking about issues not only subject to this bill but more broadly, to really understand what the opportunities are but also what the challenges are. What I can say is we've also invested in grants to support people like the Tenants Union, the Community Housing Industry Association and the RSPCA to also get the message out on how to apply for a pet and also people's rights and responsibilities. We've seen strong engagement on these issues with approximately 56,000 website visits and a high number of downloads of the pet application form, about 31,000 downloads. And we're seeing about 6,500 to 7,000 visits a month to our rental pet website. So we can see there's a strong public interest here. And I hope I can answer any questions the committee have today. Thank you for your time.
Thank you. And thank you for that detailed opening statement. That was helpful. Thank you. We've heard today, one of the issues that's been raised today is this whole issue where, and I think there's some pretty strong agreement that renters shouldn't have to declare that they've got an animal, particularly from groups that represent, for example, people living violence. And then there's some agreement around, this idea of a grace period, and there's some disagreement about how long that should be. But then I suppose the biggest issue that seems to keep coming up is if the landlord says no, on a really practical level, what does that mean for the tenant that right at that moment has an animal potentially in their care? And I guess I wanted to get a bit of an understanding from you in regards to what does happen. If they wanted to apply to NCAT, if they felt that it was unreasonable, what do they do with the animal during that time? And whether you've had any discussions with the Minister around some of the amendments that are being proposed today.
Okay, so in a scenario where a tenant's moved into a property and they've been refused a pet, I can take a recent example. There was a dachshund, colloquially known as sausage dog, refused in a townhouse in the inner west. So there's a couple of options available to the tenant. In the first instance, in this case, the tenant contacted us at Fair Trade and we were able to say to them what might be the reasons that the landlord has said no, and they suggested to us they just said no, they didn't give me any information. And so we offered to call the landlord. And so what the team do in Fair Trading is they'll give the landlord a call and they'll say, hi, this tenant's seeking to have this sausage dog in this townhouse, they're going to walk them, the park's adjacent, they've got a plan in place to look after them. Do you know that if you go to NCAT and they make a determination that's binding, we're here and we can resolve this matter between you and the tenant now? And in that particular circumstance, the landlord agreed to let the tenant keep the pet. Sometimes it's about information. It's about the landlord, maybe they're not aware of their responsibilities or what, or what can happen at NCAT. And also we can intervene and try and find a solution there from the fair trading perspective. I've also seen examples where people haven't come to fair trading and they've gone straight to NCAT. Now, NCAT don't routinely collect information on pet applications, but we are obviously very interested in this. And what I can say is they've given me information which they've had to manually count. From the 19th of May to the 31st of January, they've seen 61 tenants lodged applications. Now, this is approximate, it has to be manually counted. And this was where there was orders sought on keeping animals, and of those, there were no provisions where the landlord was granted approval to refuse the pet. There were 16 examples that allowed the pet and 21 were withdrawn. Now, we don't know why they were withdrawn, but perhaps as it escalated to NCAT, the landlord agreed to the pet. I can't confirm that. So you have the avenue of NCAT and you also have the avenue of fair trading. And of course, we would say people can also negotiate.
I guess my concern is the more practical level. For this person that's moved into a property, I understand they've got the avenue of NCAT, but they've got nowhere to put that animal during that NCAT process. And at the moment, the legislation doesn't allow the animal to stay there. We heard that pounds and shelters were overfilling, that animals will most likely be euthanised during that process if they did drop them there. Many people probably don't have a friend or relative to randomly take an animal during that process. Even in the case of contacting fair trading, and I remember many years ago I contacted fair trading for a rental issue, not to do with animals, but I remember that was still a 2 or 3 week process of negotiation within fair trading. But under the legislation currently, once that animal is given a no, I mean, that tenant then becomes in breach pretty quickly after that no. Much longer, and those processes are going to be much longer than they would be able to have that animal. So just on that very practical level,
So what I can say is there are provisions under the Residential Tenancies Act for the tribunal to make what's called an interim order to allow the pet to stay until the matter is heard in NCAT. So it's section 188D of the Residential Tenancies Act for reference, and essentially it's a possibility for a member in the tribunal to basically say maintain the status quo or prevent further harm until a formal decision of NCAT is made. So should the tenant request the matter to be heard at NCAT, they could also request for the matter to have a stay, for an interim order to be put in place for that pet to be retained. Now, there's a couple of considerations. Interim orders are best placed with NCAT because it depends on the circumstance. Like if it is wildly unsuitable and perhaps somebody is at risk, there's many case studies, then it's best for NCAT to make that decision based on the suitability of the pet for the home, which is why we really want to focus on that merit-based application, right pet for the right home in the right circumstances.
But how long does that process take if the person is immediately in breach?
If they apply for the pet in the home within the 7 days, they're not in breach. They've done the right thing.
Yeah, after that 7 days.
And then, so the landlord then has 21 days to respond. Say they come back that straight away and they say no, and the tenant disagrees. They don't agree with that. They can immediately apply to NCAT the next day and also ask for the stay the next day. And the stay can go in place as pretty much immediately, depending on the processing time from NCAT. But interim orders are quick. They're quicker than the hearing because they're in place to reduce harm until the matter is heard.
And what about some of the concerns we just heard from the last panel, that this is just simply something that if somebody has just left a violent situation, they've got children, they've got animals, they're literally in survival mode, that there's just not a chance that they'll be able to engage in this process, that they'll understand that there's interim orders, that they'll have the time, the ability, the understanding of the legislation to even jump into that. You know, what do we do there?
I completely understand and empathise with the challenges, and we've just been through the domestic violence reforms, the Residential Tenancies Act, and we're spending a lot of time with victim survivors as part of the development of the regulations. And while that's not in that bill, of course these things come up in this forum as well. What I would say is that's why we fund organisations like the Tenants Union. We fund them $17 million a year, and they're in place to support the most vulnerable to navigate issues where they would need support beyond information that they might get on an advice line from Fair Trading, or information that they might have to seek out themselves. And they can provide support for people to attend NCAT. But I appreciate in each person's individual circumstances, it is stressful. I'm not saying that it's not stressful, but without the grace period, if they move in with the pet, they could just be completely in breach and have to leave the tenancy. At least we're creating some space for that discussion to happen and to enable them to have a pathway to potentially keep the animal.
But wouldn't it make more sense to, you know, given that there is already a 7-day grace period, to extend that grace period for the NCAT process, or for people that would have to be forced out of a home, particularly given, and obviously this was another amendment that people wanted, but particularly given there's no requirement even for the landlord to let tenants, potential tenants, know that this property is actually not suitable for animals, and they may not necessarily know the landlord lives on the property, and some of the other broad reasons that can be given.
It's a difficult one to get the balance right. If the landlord had provisions to say this property is not suitable for pets, my concern is we'll return to the 2022 figures where 9 in 10 properties say no pets, and we're in a position again where we don't get the cultural shift that we want to see, which is acceptance that rental homes are homes for life and people want to live in their homes in a happy and connected way. If a landlord lives in the home, that doesn't automatically mean they won't want a pet. Like, it really is dependent on the type of pet, the circumstances of the home, and the preference of the landlord. So,
sorry, just to clarify, I don't think the assumption is that the advertisement that it's not suitable is automatic. But where there are situations where a landlord says, I live in the home, that's one of the reasons I don't want an animal, that they would say under one of the bylaws or laws, you know, that it would be unsuitable for me.
And these are absolute possibilities for consideration. I think the concerns I would raise is what we've heard from the feedback is that the unintended consequences of that is that people would just say, I don't accept the pet, or that the fencing is improper, and they won't make the investments needed to keep the quality of housing, or they won't take into consideration the merits of each application on the pet, on the suitability of that pet. Essentially, if the landlord says, I live in the property and I don't want dogs, how much information would there be in the adverts? Would it be size and breed specific, or would it be, like, there's a lot of considerations there that could have unintended consequences that would limit pets in rental homes. So that's definitely something that was brought up a lot in the consultations as part of the original pet reforms, and also in the discussions around privacy, how much information, when and where, and to what end and to what balance. So these are the things we're considering when we made recommendations.
Thank you. And I guess the other thing we heard a lot of today was just that, you know, that given that it's so heavily weighted towards the landlords and the agents, and it's going to remain extremely difficult for tenants, that it really kind of pushes tenants to essentially not declare when they've got animals, because of this fear of moving in with an animal, doing this 7-day process, being told no, and then, you know, not really having, you know, not knowing what to do. If they don't have the abilities or the finances or the resources or the energy or the time to go through this NCAT process, and they don't have the finances to break the lease, they don't want to lose their animal. They kind of, there's no pathway really there for them. And so that's sort of encouraging people to, they're less likely to declare that they've got an animal moving into a property is what we're hearing.
Yes.
Is there then consideration of some of these amendments just to kind of even out the playing field so that it does work in some way to protect tenants with animals, and looking at some of the amendments that the various organisations have brought forward today?
Any amendments will be a decision of government. What we heard from renters was they won't, as you've rightly pointed out, say they have a pet when they're moving into the property. And the flip side of that is without the grace period, then they're immediately in breach. And so the grace period is the pathway of balance that we're currently in right now. That proposal is to seek that balance for renters, to enable them once they're subject to the outcome of the bill, if there's a possibility that the regulations will further determine what's in the application form. We heard strongly from many representatives today they would seek not to have people asked if they have a pet. If that is the outcome, then that plus the grace period protects people to move into rental homes.
Well, it protects them to move in but not to stay, I think is the big problem there. And so, yes, it does protect them to get into the market, but it doesn't protect them to be able to stay there and to stay there with their animals. And so I can just see this avenue of, if it was me, if I was moving into a rental property and I had to, go in there and have that 7 days, it would just seem like such a massive risk. You've just signed a 12-month lease. There's a very good chance that the person will say no for reasons that you're unaware of when you've applied and moved in and signed the contract. That the safer option is to then hide the animal than to risk declaring it and being told no and having to deal with a court case or any other process that's coming forward with that.
I see. I guess what I would say to that is while the evidence is largely, we're still gathering the evidence that we can, it's hard to refuse a pet. Like, there has to be very serious, evidence-based grounds for saying no to the pet. So any unreasonable refusals are unlikely to eventuate in the landlord's favour. And so the majority of people who would have a cat or a dog or, a rabbit or some fish, like that's the majority, are most likely going to be able to keep the pet in their home. And so, yes, there are other cases, and perhaps what you're describing is absolutely a possibility. It is a possibility. And so this seeks to try and get the best balance for the most people in the best circumstances.
And I guess that sort of goes back to some of the reasons why people were talking about advertising where there's a clear reason why they would have to reject it, which may not necessarily be obvious to a tenant moving in. And so you've got this issue where a tenant has applied for a property, they've been approved, they've signed a lease, they've moved in, and then they've been refused on one of the reasons that they are allowed to say no to. So then the landlord says, actually, I reside at the property upstairs. That's not another renter, that's me. And so they've actually got then like a genuine reason for refusal. What happens to the tenant in that situation?
Well, they couldn't refuse it in that situation. But I get the intent of what you're saying. If they live in a separate property, they have to consider the property in its own right. If they live in the house together, though, okay, let's say an example like that, and they live in the same house, and they don't want the animal, then yes, you're right, they could refuse that. So I absolutely understand what you're saying, that they would be able to declare that I live in this property and I'm allergic to cats and I have medical information to suggest that I would never accept a cat. So I'll put that in advertisements. For this rental home, I live here and no cats. I understand what you're saying.
Yeah. Okay, good. And I suppose the only other question I had, which I've just forgotten at this point, was just in regards to comments that were made this morning by the Animal Welfare League and the RSPCA, that the previous legislation's been in place for 12 months now, and they said that they haven't seen any change in regards to the number of animals that are being surrendered because people cannot enter the rental market or find rentals that is allowing animals to come in. They said that on that side of things they've seen no change. What is your response to that?
I would be interested to obtain some of the insights from them, and I'll take that as an action following today to do that. I'm definitely in touch with them. I'm absolutely interested to understand the data around that and what they're hearing from the people who are surrendering the animals. I mean, the ultimate intention was to make it easier for renters to keep pets in their rental homes. We've seen an increase in inquiries at fair trading. We've seen an increase in complaints. So people are engaging on the issue. As I said, we've seen strong public interest from visits to the website, 7,000 visits a month on this issue. People are engaging. So I haven't heard that directly myself, but I will seek that information out. Thank you.
Thank you. Ms. Aileen McDonald?
Thank you. Did fair trading consider, say, requiring pet consent to be resolved before the tenancy commences?
So when it comes to applications for rental homes, that's what this bill is proposing, to standardise application forms. And so it's proposed in the bill that the regulations would determine what the questions are to be asked. And we have discussed at length with the industry reference group, which was formed of academics, experts, tenancy managers of varying degrees and sizes, as well as privacy experts, property technology organisations, and renter advocates. That group, we went into lots of customer journey, like renter journeys, and there was lots of discussion around that, and there certainly are proposals for what those regulations might look like. It's definitely being discussed that you wouldn't seek a request to ask if a person has an animal, in the same way that it's being discussed that you wouldn't ask a person how many children they have, because there's concerns around discrimination. So those things will be further developed subject to the outcome of the bill.
And so how does the bill prevent, say, informal screening of tenants with pets during the application stage? Say, if landlords or agents ask about pets outside that form?
So the intention of this reform is to limit the information that's collected to protect people's privacy, and also recognising that a renter shouldn't have to divulge certain information that doesn't pertain to the success of the tenancy. And so what the goal is to standardise the application form and only require what's absolutely necessary and prohibit what's not. And so if a person seeks to circumvent that application form process by going, just a few extra couple of questions, and that was reported to us as the regulator, then we would be taking significant and swift action around the conduct of that provider. Right now, I can tell you that some of the application forms that I have seen are unconscionable. People are being asked for 6 to 12 months of bank statements. They're being asked if they have tattoos, specifically if they have neck tattoos. They're being asked about the care arrangements of their children. They're being asked what kind of role and job they have, particularly if they're in the gig economy. There's a lot of discrimination there. And so standardising the application form and limiting what's asked based on evidence required for a successful tenancy, so the landlord can have assurance, is absolutely the goal of this, and anyone who would step outside of that would face the consequences of the law.
So the consequences, what enforcement powers and resources will fair trading have or rely on to ensure compliance with, as you've outlined, to ensure that, they don't have something outside of that application form?
So on average, first of all, can I say we stood up the New South Wales Rental Task Force, and the government invested $8.4 million to enable us to have a dedicated compliance and enforcement team. We've since restructured at Fair Trading and put even more resources into the Rental Task Force, and we've also stood up an investigations team specifically. And as it relates to privacy, those people, should the bill pass, would be trained on that, as well as our complaint handlers, so they're ready to respond. Consumer protection generally relies on consumers telling us there's an issue. So that is absolutely a component. We wouldn't be able to be everywhere, but we would rely on reports of that. And you can take a witness statement, and you can also collect evidence through any exchange of information they would have had to substantiate that. So that's one method. Another method as well could be proactive initiatives that we often do, where we propose as renters, or we turn up as renters, and to engage with the conduct of agents to see how they behave.
And so will you then maybe say publish that enforcement data or compliance reports?
Yes, we generally publish a year in review report from Fair Trading at the high level to outline our breaches, penalties and activities undertaken.
And how will you collect and publish data, say on pet, will it be on pet applications, refusals, NCAT disputes, and the impact And in collecting that data, will that be then the impact of the reforms be evaluated or can be evaluated?
I'm certainly very active in monitoring the reforms and look at a number of matters from investments and supply of rental homes right across to complaint matters and compliance outcomes. They're reported in various methods through, as I said, the year in review report, but also through presentations that we do to industry and the sector as well, through quarterly forums with key stakeholders and also large forums that we do with agents. On average, we get about 5,000 agents attending those. We wouldn't have access to the NCAT data, but any data that we are in control of would certainly be considered in that. As it relates to the pet information, we have a voluntary end of tenancy survey that we seek from tenants, and we're currently revising the questions in that, and one of the questions we really want to get information on is pets.
Yeah. And then how do you think the bill balances, say, the objective of protecting renters' personal information, but also the legitimate need for landlords to assess tenancy risk? Now, I understand, like with that, some of the forms, some of those questions shouldn't be asked, but how do you where's that balance?
So we stood up a specific industry reference group to help us to strike that right balance, and we spent, it wasn't an hour consultation, we spent days in half-day workshops and full-day workshops working through what is the problem that we're trying to solve, who's it a problem for, and how do we solve it. And so we kind of went through kind of line by line on how do you collect the right information, what do you need to know, what happens in practice, what would be the consequences of having a cover letter, not having cover letter, right down to that level of detail. And so we iteratively went through all of that with all the voices in the room, so that we didn't just have one view, and then we take the kind of summary of that. Each party could hear from each other. And that enabled us, while we didn't have always consensus on every matter, it's quite difficult to get that, I have to say, in this space, we certainly canvassed the issues and could see what we were able to make recommendations on, what we felt was a balanced approach based on the evidence, the feedback, and also the extensive consultation that was done through the Have Your Say process, which there was thousands of surveys and 400 long form submissions as well.
So did you then, as part of that process, did you do any modelling or analysis, and then did you also look at, say, unintended consequences?
Yes, we always look at unintended consequences and try and, as much as possible, flush them out. We've got to kind of bottom that out, consider them with stakeholders from different perspectives. When it comes to the reforms around protecting privacy, they're strongly welcome generally. I was interested to hear the panel earlier this afternoon from industry. A lot of agents say to me, we want this because it will save us time and we don't have to kind of race to the bottom on asking vast amounts of information. We can just be contained. Prescribed forms is the top thing I get asked from agents all the time. Prescribe it, keep it simple. It's particularly for licensees in charge who are bringing in entry-level property managers to their teams and wanting them to be consistent with more experienced property managers. So mostly they were widely welcomed. In terms of unintended consequences, discussions around things like cover letters, that was really interesting. People felt shouldn't need a cover letter because it should just be on the application. Others felt cover letters were important because they could help a person tell their story. People were concerned if you tell your story, you breach your privacy. So there was really interesting discussions around that, and further information would be needed in consultation to refine those in the regulations.
And I'll just follow on from one of the chair's questions about the 7-day grace period. What evidence did fair trading rely on when determining that 7 days?
Generally, when it comes to time periods, it's mostly a discussion with stakeholders. Because it hasn't happened yet, there's not a lot of evidence that you draw from. And so there was a lot of discussion around what's reasonable, what would work in practice. And there was a strong view from tenancy managers and landlord representatives, property managers, that anything beyond 7 days would, noting that there was then a further 21 days for landlords to consider the matter. We were now at a month, thereabouts 28 days. That was sufficient. And when we spoke to tenant advocates and others in the room, their focus was on the grace period at that time, and appreciate there was certainly calls for 2 weeks, 3 weeks, a month. There was lots of time frames discussed. Where we landed was really there was recommendations made, and then the government's decision around the 7 days is where we landed.
Okay. And I guess I'll just clarify, so with the regard to the mandatory, say, standard application form, how prescriptive do you think that form will be, and will agents still be able to request additional information outside of that form?
That will be very prescriptive, and it will be prescribed, so you can only ask, and anything outside of what's permitted would be prohibited.
And then otherwise compliance or enforcement might
would trigger that. And I note there was comments earlier that represented that this reform would ban third-party apps and would require manual processing. Can I just put on the record that's not the case at all? In fact, we had the largest prop tech company in Australia at the table drafting this with us from a recommendation perspective on the industry reference group, and the intention is to absolutely bring prop tech into the Act in a way that it hasn't been in before.
Okay, thank you, Chair.
Thank you. Government?
Is there anything that you wanted to particularly address arising out of the evidence that you've heard today, or perhaps in any of the submissions?
Look, I would just say that, as always, we're trying to seek the balance and support people to live well in their homes, and this grace period recognises the difficulties that people have when applying for a rental home, and the broader pet reforms recognise the culture shift to accepting pets in a home that is being sought through these rental reforms. So I hope that that has been helpful for the committee.
Thank you.
Ms. Boyd?
Not from me. Thank you, Chair.
Okay, thank you. I've just got a couple of quick follow-ups then, if that's right. I think we've still got a couple of minutes of time. I just wanted to ask, a number of stakeholders also called for better data collection and reporting in relation to animals in rentals, and I just wanted to understand what your office is doing at the moment in terms of data collection and reporting and tracking the impact of the reforms.
So we have a number of things underway. I'll start with the survey. So the first survey we have is the mandatory end of tenancy survey. That's a requirement for landlords to tell us why a tenancy has ended. We collect that in the rental bonds online system. At the same time, tenants are asked the same questions. We use that for compliance as an indication of intelligence. And so tenants is voluntary, landlords is mandatory, and that gives us indications of why did this tenancy end. And the landlord might say, because I was selling the property, but if the tenant says something different, we put that on a flag, and we audit the flags and we check the flags, so that's some intelligence for us. We also have a voluntary end of tenancy survey, and we're going to work on renaming the survey so they're nice and clear for people. And that's all about, tell us about your tenancy and tell us about why your tenancy ended. And in that survey, we ask things like, did your tenancy end because of a domestic violence termination notice? And we ask more detailed questions along those lines. In addition to those surveys, we have regular engagement with tenants and landlords through various forums, as well as property sector representatives and industry representatives. And we also do a lot of market monitoring. So we look at information like the bonds data, rent prices, rental listings, availability of rentals in different areas, and we infer from that what changes might have occurred and when. For example, I heard earlier today there was an assertion that the reforms had led to a decrease in rental homes. There's no evidence to suggest that whatsoever. We've seen an increase in bonds, an increase in rental supply, stable and increasing. There's been no measurable reduction.
Thank you. The Tenants Union proposed that landlords should be required to report on the outcome of pet applications lodged during the tenancy agreement to be disclosed during that mandatory survey through the rental bonds online. Is that something that's being considered or being done?
Happy to consider.
Okay, thank you. They also suggested working with NCAT to access that de-identified data in regards to the outcomes of the applications for animals going into the tribunal. And I know you actually mentioned the data here today, but is that ever going to be sort of public information, or is it public now?
So NCAT are constrained by their current system insofar as they don't have an ability to automatically collect that information, and so it's a manual count, so I can't commit to that information being available regularly, and it would get difficult to collect that at scale over a long period of time in the current system. So what I can say is, though, we meet really regularly with NCAT. I have a regular meeting with them, and we talk about things like trends and issues that they're emerging, and pets has never been even on the agenda. It's just not a high frequency matter.
Thank you. We also heard earlier today, and I don't remember if it was the Property Owners Association or the Real Estate Institute, but they were asserting essentially that that there's really no problem with people being able to get into the rental property market with animals, and was sort of suggesting that there's no data or hard evidence that that people are being rejected because they have a pet. But of course others have said that that data isn't and can't really be collected. Does your data in your opening statement, I think you said 10% were originally being advertised, does that kind of show us that it really has been very, very difficult for people with animals to enter the rental market?
I would agree, and I would also say that we hear regularly from tenants that it's difficult to apply for rental property with a pet in their possession. And I also openly hear from agents who advise that if a person has a pet, they're not the first person considered. Now that again is based on the individual, and there's 75,000 licensed agents across New South Wales. I'm not saying that's everybody, but we certainly hear that anecdotally is a practice.
Thank you. When I asked you before as well in regards to what people can potentially do once they're refused a pet, and one of the options you mentioned was to contact Fair Trading. How would that work if that person's kind of immediately in breach of their lease?
Well, we would ideally want them to call us before they're in breach, and so they could contact us.
But I mean, what if they can't? Like, what if the landlord tells them sort of on the last day of that 21 days that the landlord can ask, they're in breach kind of the next morning?
So the minute they apply to NCAT, then the matter is open for consideration. So,
but they're still in breach even if they apply to NCAT?
No,
under the current legislation.
So that doesn't really work like that in practice. So if, for example, even if you don't pay your rent, and you're brought to NCAT by your landlord, you can stay in your home under an interim order until that matter is resolved at NCAT. So it's not like the consequences are that you have to leave or remove the animal. Like I said earlier, at that point, say it was worst case scenario and it got to day 21, they got back to them and said no, 5 o'clock on that day. 9 o'clock the next day, they could apply to NCAT or that overnight and request for the interim order as part of their application for NCAT to say, can I contest this decision, and can I keep my pet while the decision is made? And so NCAT can respond to that. This hasn't been widely tested. It's brand new legislation, so I can't say what the outcome be. I can't give the committee any confirmation of trends, but I can say that's possible.
Thank you. Your submission suggested that tenants should be taking sort of proactive steps, so checking with council rules, checking if the landlord themselves resides at the premises before entering into a tenancy agreement. We heard just before you from domestic violence organisations that some of these people might be trying to leave a violent situation. It might be urgent. They might have 10 applications. That's not possible. Do you think that sort of shows some potential, I suppose, support for different sort of amendments that could look at making it mandatory for landlords to disclose some information in those rental advertisements?
What I would say about the discussion on bylaws is it's not possible to really refuse a pet in the strata. Like, there's a lot of protections in strata around pets, and understanding the bylaws starts to become more important as it relates to the type of pet. Similarly with the council rules. For example, if you have chickens, they're mostly permitted in council properties, probably not permitted in strata. But if you have a rooster, that's not permitted in most council areas. And I'm being specific about those type of things because as a pet owner, these are the kinds of things you would need to know anyway and you'd want to have regard to. It's certainly not the intention of Fair Trading to put any unnecessary burden on anyone, particularly vulnerable people, when they're seeking a home. And that's definitely not anywhere near the intention or the design. And the unintended consequences have been thought out. It's more from a practical level. What pet do you have? Have you thought about, is this property suitable for you and your pet? there is an onus on the pet owner to do that regardless of their circumstances. So that would be the first thing. And also, as it relates to the bylaws, it's important for tenants to understand their rights and their responsibilities, and we really strongly encourage tenants to check what are the properties they're moving into and ask as many questions as they can. But I do hear from the feedback today and also from yourself, Chair, like the opportunity to be specific is something that we will absolutely take under consideration.
I thought of one more question.
Go for it.
We heard from the Property Owners Association this morning, and I know renters currently submit applications through third-party platforms. The Property Owners Association said they will now have to do that manually. So then my next question, I thought that might be it. So how will fair trading ensure that those third-party platforms comply with the privacy obligations as at the same, as the agents and landlords? And will there be compliance and monitoring of those platforms?
Yes, so this is really to the heart of the design of this bill.
Yes.
To consider the fact that we are living in significant advancements in the property technology space and recognise the role that major platforms provide in processing applications for rental homes. In fact, it is the major platforms that this bill was designed around, and so the protections speak to them more in many respects than others, because we know that people, when they apply through platforms, they keep those application forms and apply for multiple homes over a period of time for potentially the duration of being a renter. And we also know that most renters only live in their homes for up to 18 months. We're starting to see that tenure get longer, which is a good sign, and another thing we measure as part of the reforms. But we also know that tenants are the ones that end the tenancy more than landlords. So they might keep their information on file and want to reuse that. We want to make sure that those providers aren't misusing the data they're holding in the interim periods. And so the protections in this bill enable us to have oversight of that and also intervene and have compliance and enforcement.
And say there's a data breach through that, say, rental application process, where will the liability sit? Will it be with the landlord, the agent, or the platform provider?
It depends, and I don't want to be vague about that, but it would have to, I'd have to be across the particulars of what scenario we'd be talking about. How big is the organisation, whether it would be the jurisdiction of the Privacy Commission at the Commonwealth level or whether it be our jurisdiction would depend on the severity of the breach. And also, I would have to say the scale of the organisation, the severity of the breach and the response would be determined at that point based on the complaint. But we have regular engagement already at the Commonwealth level with the Office of the Privacy Commissioner to discuss how we might respond to issues like that should they emerge.
Okay, thank you.
Thank you, and thank you for your time and giving evidence today. We really appreciate it. I note that owing to the extremely tight time frame in regards to this committee and our deliberative, that there's a very limited window for any answers to questions taken on notice. But the committee has resolved that the transcript, any corrections that you may have, answers to questions on notice, clarifications of evidence, or any additional information that you wish to provide to the committee needs to be done within 24 hours of receipt of the transcript to yourself. And the Secretariat will be in contact and provide that transcript very soon. So thank you again for your time today. We appreciate it.
Thank you. Thanks again.